Lagi.
Man, I can't get the fucking video to work on this.
All right, ladies and gentlemen, I have 9 o'clock. I'm going to go ahead and call the civil dockets and criminal dockets. I'll start with the criminal dockets. I'll ask for announcements from the attorneys on how much time they think they may need to proceed with their case. If you have an attorney, your attorney will answer for you unless you're either answering because you don't have an attorney or your attorney is not online, or unless I'm asking you to answer because we're wanting to make sure you're present. Please keep your devices muted. State versus Micaiah Kenton. Saw Mr. Cedios.
Micah Kenton's present, Your Honor. We'll confer with the state.
Joel Quintanilla, is that still monitoring his medication and commitment, or what do we have?
Your Honor, we have the motion to enforce meds this morning, Your Honor. The doctor is present and we are ready to proceed.
Defense is ready.
Okay, how long do you expect?
Maybe 15 minutes at the most, Your Honor.
Okay, and is Mr. Quintanilla available?
Kenton.
Okay, is that him at the sheriff's office?
No, Your Honor, he's up at North Texas.
That's what I was thinking.
He's at Vernon, Judge. I spoke with them. He expressed an interest in being a part of the hearing, although I don't think he cares about the subject of the meeting. I think he just wants to vent some frustration with the system, but
Okay, so
I did.
Is he waiving personal appearance, or do we need to get him online?
No, I'm right here, Your Honor. I'm right here. Can you hear me?
Yes, it says Elizabeth 1901.
Yes, sir.
Yes, sir.
All right, Ms. Quintanilla, I'll mark you present. You'll be the first case we hear.
Yes, sir.
State versus Tristan Humphus.
He's present here at the probation department.
And I think he's ready for a plea. We just have to complete the paperwork, Your Honor.
All right, mark him present. Donald Harrell, or Harrell?
Your Honor, I believe that's Hurley. Your Honor, I think we'll be able to get that case resolved today.
All right, I'll mark him present. Stephen Dotson.
Your Honor, I believe he is in custody.
And I'm present here for him. I believe he's right there. This is staying on docket, so I just need dates at this point, unless he has something that he would like to address.
All right, but he can take that up with you in a breakout room. So please get whatever dates you need in chat from Ms. Riley. Richard Talamantes. All right, Mr. Flores. No show, I'll recall. Mike?
I do see Richard Telemontis on there, Your Honor.
Yes, hello.
Yes, okay, I'll mark you present, thank you.
Hello.
I'll mark you present, sir. We'll check on Mr. Flores. Mike Shower.
Robert Gear for defendant Michael Ray Shire, judge. Mike, you online?
Come back. Yes, Mr. Gear.
I sent him the login info yesterday. I'll get in touch with him, judge, and log him on.
All right, mark him no show. Julio Salazar.
Judge, he's in custody. We'll confer.
Christopher Ward.
I'm present for Mr. Ward. I don't see him on. My understanding was he was logged on. This is a case I don't believe we're going to be able to get resolved, so I'd like to reset if we could for another pretrial.
All right. Well, is Mr. Ward present?
I'm trying to flip through and see him, Your Honor. I don't see him, though.
Okay, I'll recall, and for all the attorneys that will, anything that's being reset, if it's being reset by agreement, there's not a contest on that. Just get the date from the coordinator's office, and she just posted those from the criminal cases. And all you need to do is send a message in chat to everyone in the name, date format. And you do that and you're free to go. But in
Thank
that
you, Your Honor.
cause number, name, date.
Yes, sir.
Alicia White,
Judge, she should be logged in. I'm here for her. Miss White, if you're there, can you say something? I'll try to look for her, Judge. I wanted to reset to 4:13 if the state has no objection. If she should.
a recall, Robert Mayeen. Is it Mellon or Mayeen? Mayeni.
It's Robert Moline, sir.
Okay. All right. I'll mark you present. Mr. Vargas online. We'll check.
They should be, sir.
Maria Anzaldo.
Good morning, Judge. I'm present and Miss Anzaldo is supposed to be at the probation department. If we can recall, because I spoke to probation, she's not there yet.
Recall.
Thank you.
Jose Arroyo.
Your Honor, we had a call from Mr. Baird who said that he would check in at 10 o'clock. He was taking care of something else real quick in another county.
All right. I'll mark no show and recall. Cameron Mathewson. Mr. Fiegel. No show. I'll recall.
Yes. Yes. Hello. I'm Cameron Mathewson.
All right, Mr. Mathewson, have you heard from your attorney?
Nuh-uh. I don't know where he's at. I've been trying to get in contact with him, but he hasn't made contact back.
Okay, I expect him. We'll try and get in touch with him. And I'll mark you present.
Okay.
Michael Shower.
Same announcement, Judge.
Angie Ford. Mr. Briggs,
We're conferring on that, Judge.
is she present?
She should be. I gave her the information.
Ms. Ford, are you present? All right, no show, I'll recall. Abe Herrera III. No show.
He's here in our lobby, Your Honor.
Oh, okay. We'll wait on Mr. Cabañas. Aaron Taylor.
Good morning, Judge. He is present and that'll be a plea. Aaron, if you'll just please stay present.
Here, present, Your Honor.
Okay, Christopher Ward, I saw him here. All right. Mr. Ward. Well, he checked in. I'll come back. Zachary Hyman. Mr. Sidios.
I'll check on his whereabouts, Your Honor.
No show, Norval Lynn. I saw Mr. Lynn sign in, I believe.
He's present, Judge. We'll confer. Thank you.
Royce Smith.
Council's present, Judge. Royce, you here? Judge, I'll get in touch with them. You can recall.
Jose Barrientos III.
Your Honor, he's here in our lobby.
Mr. Baird's coming at 10, so. Austin Bess.
I'm here for him, Your Honor. Austin, are you present? If you can recall that. Oh,
Okay,
you
he's
are.
here. I'll mark you present.
Perfect. Thank you.
Sergio Diaz.
I'm here, Your Honor.
He's present, Your Honor. If we could just get this reset for entry of a plea, Judge.
All right, you get with the state and the court coordinator's office, Ms. Riley, for dates, please.
Thank you, Your Honor.
Thank you, Your Honor.
Sean McHaslett,
Council's present, Judge. Sean? Judge, please recall.
I'm here.
Oh,
I'm here. I'm
Sean's here.
sorry. I was trying to figure this out.
Good morning. He's here, Judge. We'll confirm.
Nancy Davis,
Good morning, Judge. I believe I see Miss Davis on, and we are just going to be resetting her case this morning. Miss Davis,
I'm here.
thank you.
all right, I'll mark you present. Nathan Gonzalez,
Present, Your Honor.
all right, have you heard from Ms. Voigt?
Earlier today, about a little bit before court today. Yes, sir.
She's supposed to be here?
Yes, sir. She's just gonna ask for a reschedule for 2 weeks.
Okay, that's fine.
Thank you, sir.
A lot of people have dockets all over on Monday morning. Leticia Pedrosa,
Your Honor, I don't see her. I'm present for her.
all right, no show.
I'm here.
All right. Richard Quintero, all right, Mr. Flores, all we're getting is just a little Charlie Brown teacher squeak in the background. You need to check your microphone. Can't hear that, sir. All right, who is here on the Moto E?
Me,
Who's me?
Michael Shower.
All right, Mr. Shower, I need to
That's my client, Judge. We'll confirm,
direct
please.
you to put your cigarette out while you're in court. All right, so no show on Quintero. Okay, I saw Ms. White appear, and I don't know if, are you online? Alicia White.
Judge, she just logged on. She's on right now. Miss White, say something. It's she's having issues with her phone, Judge. I'll continue to work on that.
All right, and Mr. Ward? I saw him sign on. I'll recall. Anybody else told to be here today just on a criminal case?
Sir,
Yes, Your
this is
Honor.
Robert Mullins, sir. Do you want me to disconnect so that way I could get in touch with my lawyer so that way he could come in? I know that this morning he asked for a reset.
No, sir. He'll show up. You just need to hang out.
Sorry, sir.
If I may, Mr. Vargas asked me to announce that he's going to need a trial and wanted to go to the next date available.
Okay, just post that in chat if that's what we're doing.
Yes, sir.
Your Honor, this is Kathy.
Yes, Ms. Starling.
We were asked to put Mr. Lockbaum, the extradition out of Wilson County on today's docket, and you approved that?
Okay, yes, that's on the add-ons as a habeas corpus, so technically civil.
Oh, I'm sorry. Yes.
So we'll get to it. All right, anybody else told to be here today just on a criminal case?
Judge, this is Mr. Smith. I just want to make sure y'all know I'm here. I don't on the phone.
All right, I'll mark you present, Mr. Smith, Royce Smith.
Thank you.
And Judge, we got a message from Lisa Voigt. She was going to be 30 minutes to an hour late this morning.
Okay, and the 830 phone number that ends in 976 that keeps making racket, who is that? All right, I'm muting him. All right, Ms. White's here now. Okay, anyone else?
Judge Sylvia Gonzalez, I apologize for being late. I'm here on Cameron Matheson, the attorney.
All right, what case is it?
It's on CRW 2005-108, Cameron Matheson.
On page 3, Judge, second to the bottom.
Okay. For some reason, it doesn't show up whenever I type in CAM. Huh. All right. I'll mark. Okay, so you're here from Mr. Fiegel?
Yes, Your Honor.
All right. Okay, so I'm gonna find the coordinator and make her the host. Ask you to make me the co-host, Ms. Riley. And anyone who needs a breakout room, please send a chat message to Lori Riley. She will get that. Then I'll start on the civil dockets.
Judge, real quick, I believe you said you saw Alicia White. Can you
Yes,
go ahead and
I've
make
got her
sure-
marked as present.
Okay,
And
thank you.
Zachary Hyman just checked in, I'm told. He texted me.
Okay, I'll come back.
Okay.
Cassandra Blackman versus Stephen Blackman.
That case has been dropped, Judge, reset on request.
All right, Bird versus Sparkle Car Washes of Texas Limited.
Good morning, Your Honor. Mark Taylor here on behalf of the plaintiff, Randall Bird. I believe this will take less than 15 minutes.
Good morning, Your Honor. Paul Lawrence or Sparkle Car Wash in Coleman.
All right, so you agree 15 minutes?
I would think less, but that's fine.
Okay. Angel Rodriguez versus Alamo Renovations et al.
Good morning, Your Honor. This is David Aon for the plaintiff, Angel Rodriguez. This is a default judgment. Unfortunately, my client was called out of town on an emergency and won't be available for testimony today, although we have filed all the required documents.
Okay, is this against everyone?
Yes, Your Honor. No one has filed an answer. Pardon me?
All right, so this is unliquidated damages?
Yes.
So do you want me to just look at the file, and if it's correct, I'll give you an interlocutory judgment on the merits, on liability, and then we can prove up damages later, or do you want to just reset this?
Well, Your Honor, it's a trespass to try title case in
Oh,
relation
okay.
to some property. I have submitted a proposed judgment also.
All right, sir. All right, so but you're not going to have any live testimony today.
That is correct, Your Honor.
Okay, I'm going to mark this as after court on, I don't want to rush through a T3, and I will look at this. If there's any issues, we'll get back with you. If not, I'll sign your judgment. And you've got your military service affidavits and certificates of last known address and all that on file?
I do, Your Honor, for two of the defendants. One is an LLC, so of course they wouldn't have one, but I do have the other two on file.
Okay, I will look at that after court today.
Thank you, Your Honor.
Appreciate
Appreciate it. Thank you, sir.
Yes, sir. In the matter of the marriage of Cindy Hernandez and Anselmo Guia.
Here.
All right. And are you ready to proceed, ma'am?
Yes.
All right. I'll mark you A. You'll be the first self-represented case I call up.
Okay.
State of Texas versus $8,000 in U.S. currency and a 2006 Harley Davidson.
William Richmond for the state, Your Honor. This is an interlocutory default judgment. It should take 5 minutes or less.
Okay, let me just look at this offline. It's all right?
Yes, sir.
Do you have any live testimony? No?
No, that's it. If you want to look at it offline, Your Honor.
Yes, because we,
I have to be in Judge Ellison's court anyway, so.
okay, let's do it that way.
All right. Thank you, Judge. I don't think I filed the order yet. I'll file it sometime this afternoon.
Sounds good.
All righty.
In the 2011 800 in the interest of Colton cops.
Present, Your Honor, Chris Bird for the respondent, as well as the counter petitioner. I don't know, this is a contested, I guess what was set today is essentially temporary orders which are contested in a SAPSR. So I don't know how opposing wants to proceed, but without knowing, I would probably announce an hour if she insists on live testimony.
Okay.
Your Honor, good morning. Jody Head Lopez. You said cops. I'm sorry. The boy's name is Caps, so it threw me for a moment. I filed a first amended petition on January 29th asking for temporary orders. To date, Mr. Bird has not filed a counter petition that I have been filed with. I've only been served with an answer. So it would be my request today for temporary orders. And what is the court's time limit, Your Honor, on temporary orders?
1 hour, but I'll mark you conferring in the time being.
Okay, and Your Honor, we'll take the full 1 hour.
I'm going to direct y'all to get with Ms. Riley about a breakout room and talk in a breakout room. 1, try to settle it. 2, if not, whatever exhibits you need to have looked at, refer by exhibits and things if you're going to have those offline. I mean, in the breakout room, so that we're not using up time for each other to look at photographs of the parent and child or grandma or whatever. Know if you have objections to those or if they're going to be admitted without objection before we start. Okay. Matter of marriage of Ken Fletcher and Erica Garcia. Fletcher Garcia. All right, I'll recall. All right. Habeas corpus in re Douglas Edward Lockbaum.
Kathy Starling here on that, Your Honor.
Mr. Leday, Ms. Whitney.
Judge, we're here as well, probably about 15 minutes.
And
I would think on the habeas, it might take a little longer. I've prepared a memo for the court. I don't think it's been accepted. I can email it to the court, though. I would think it might take 30 total.
All right, I'll mark you 30 minutes. Any memos, law, motions folks want me to look at, please post those to me and to each other in chat. I'll mark you 30 minutes.
Thank you.
All right. Burns County. In the interest of Christian Aguirre, a child. That's the second case. Has that been dropped by chance?
Yes, Judge, it's been dropped. Reset to 210.
All right, Apperson versus EOG.
Your Honor, Corey Waymeyer joined by John Ellis on behalf of defendants DDR Gaddy and Stephen Bressler's trustee. We're ready to go on the first, third, fifth, and seventh motions for summary judgment, approximately 3 hours, Your Honor.
Okay. You see, I've got several things set up here. Let me go back and look this for a moment. 2 hours. How many criminal pleas might we be having?
I think 3 or 4, Judge.
Judge, actually, you can take 2 of those off because 1 plea did not show up to the probation department. And my other plea that was set this morning, he still hasn't made it into town and won't be able to report to probation until 4 p.m. So if we could get him in to see you tomorrow for a plea, can we do that?
No, I'll let you confer with the state first. I don't have an objection.
Yes, sir.
Okay. All All right, so let me ask the attorneys in Apperson to be here at 1 p.m. Let's make it 1:15. Give you all more time to get back from lunch if you do that. And we'll hopefully have everything else wrapped up at by 1:15. That sounds reasonable.
Thank you, Your Honor.
Yeah. All right, anyone else told to be here today at all? Okay, I see somebody.
Your Honor.
Yes. Yes. Mr. Harkins? All right, I'm not sure what he's doing. Mr. Harkins? Okay. All right. So on Joel Quintanilla, what is the statute or what this hearing is being held under?
He's being held under chapter 41. I believe. Let me pull it up.
Hold on, buddy.
All right, I'm sorry, ma'am. Ms. Whitney, you broke up.
Oh, I'm sorry, Your Honor. I believe he's being held under chapter 41. I'm pulling up his file.
Are we talking about Mr. Lachlan?
No, Mr. Quintanilla.
Sorry about that.
All right, but is the order for medication under chapter 41 or is that under the health and safety code?
It's under the Health and Safety Code, Your Honor. It is statute 574.104.
All right, let me pull that right quick.
Your Honor, I just emailed you the order from the DA's office on Cnty in case you want to look at that.
I don't know if anybody can hear me right now or not.
What's your name, sir?
My name is Ken Fletcher. I was supposed to be on the docket today about a divorce, finalizing my divorce.
All right, Mr. Fletcher, I'll mark you present and we'll get to your case. It's going to be a while, but later this morning.
Okay, cool. All right, thank you, sir. Do I just go ahead and check back in a little bit or stay?
I would just stay on, and you need to make sure that you have your proposed divorce decree to the district clerk's office.
Yes, all that's already been done and it should be in your office as well.
All right, we'll get to you soon.
Judge, can you hear me now?
Yes.
Oh, it's Steve Harkins. I'm sorry, I'm
Yes.
having reception issues this morning. I've conferred with the state and they're going to go ahead and dismiss the case. May I be excused and may my client be excused?
Yes.
Okay, thank you so much. I appreciate it. Y'all have a great day.
Okay, and what section are we looking at?
Section 574.104, Your Honor.
104, okay. I'm only at 081. Okay, administration. All right, so they have the chapter on discharging you from getting medication before the chapter on taking it. All right, are both sides ready?
State's ready to proceed, Your Honor.
All right, Mr. Briggs?
Defense is ready.
Okay, and the state's witness is,
Doctor, if you could pronounce your last name.
Yes, it's Dr. Yaqub. My first name is Feroz, and the last name is Yaqub.
all right. Doctor, would you raise your right hand? You solemnly swear or affirm the testimony you may give in the matter now on trial be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
May I proceed, Your Honor?
Yes, but let me make sure Mr. Quintanilla just signed back in. Is he present?
Right here.
Okay. All right, and where does this case stand? What has happened previously with Mr. Quintanilla?
Your Honor, Mr. Quintanilla, there was a motion of competency. Dr. Woods actually interviewed him, determined he was incompetent. He is, because of the type of offenses, he is currently at North Texas, Vernon's, which is up in North Texas currently. And this is obviously with the doctor's testimony in regards to medication and how the medication would help him with store competency.
Okay. All right, and Mr. Briggs, do you agree on the background of how we got here?
I'm sorry. Yes, Your Honor. I agree.
All right. Go ahead, Ms. Whitney.
Thank you. Doctor, would you please state your name for the record?
Yes, my name is Feroz Yaqub, and I'm a staff psychiatrist here at North Texas State Hospital, Vernon campus.
And doctor, what is your educational background?
Well, I'm an MD, and I completed my residency in psychiatry here in the United States, and I'm a board certified psychiatrist.
Okay. And do you belong to any organizations?
No.
And how long have you been with the state hospital there?
At North Texas, I've been here since November, but I've been working for the state hospital for the past 9 years.
And doctor, what is your current position with the hospital?
I'm a staff psychiatrist here at North Texas State Hospital, and I usually do the court work.
Okay. And when you say you're a staff doctor there, what are some of your duties you perform there?
Well, I see patients, evaluate them, interview them, look at their charts, and complete their court papers, which can include competency papers, court-ordered medications, and then testify in the court.
And doctor, are you familiar with a Joel Quintanilla?
Yes, I reviewed his chart.
And when did he arrive at the hospital?
The patient arrived at the hospital on the 28th of January, 2021.
And doctor, as part of what would his treatment involve while he's there?
I'm sorry?
What kind of treatment would he be involved in while he was there?
He's currently here for his psychiatric treatment as well as for competency restoration, primarily for his psychosis and mania.
Okay. And what is his diagnosis?
Schizoaffective disorder, bipolar type.
Okay. And as part of his treatment, would the hospital typically prescribe medications?
Yes, ma'am.
And would those medications help with restoring his competency?
Yes, ma'am.
And as of right now, is the patient able to understand what is going on around him in regards to the medication?
No.
I'm sorry?
I don't think so. He doesn't have the insight that he needs to take the medicine, if that is what your question is.
Okay. Does he lack the understanding of the consequences if he refuses to take the meds?
Yes, ma'am.
Is he refusing to take the medications right now?
Yes, he is.
Along with refusing to take his meds, has anything else happened since he has been there?
Well, he's been pretty aggressive verbally, and he's ever since he's been here, he's been very condescending. He's required some of the medications for emergency need. He's been in personal restraints. The last restraint was on the 29th of January. Yeah, he's been having issues with controlling his aggression and anger, and therefore has been requiring emergency-based medications.
And doctor, if he doesn't get those medications, would y'all ever be able to restore his competency?
It's highly unlikely that he'll be restored with this kind of a illness. He does need to be on some medication to be able to be more rational and to be able to assist his attorney.
And if he were to be given those meds, would those meds help with his temperament as well as help him in the competency issue?
Yes, ma'am.
And is he a current danger to himself and others?
Well, possibly to others based on his offense. He hasn't done anything to harm himself since he's been here.
Okay. And doctor, what would be the grouping of meds that you would be asking this court to allow y'all to give him?
Well, primarily we'll be asking for antipsychotic medications, mood stabilizers, antidepressants if needed, anxiolytics. The ones that we can administer if in case he refuses to take oral medications are primarily going to be antipsychotic medications that help both with the thought process as well as with mood stabilization.
Are you asking for any that y'all be allowed to administer any sedatives or hypnotics, I guess?
Well, the sedatives and the hypnotics are both part of our treatment in case the patient is agitated or aggressive to prevent the patients from harming themselves or others. They can be administered intramuscularly, and they can be given orally if the patient accepts to take them. So yes, they're part of the treatment.
And doctor, just to reiterate, without these without Mr. Quintanilla taking these medications, the chance of him recovering would be very little. Is that correct?
Yes, that is correct.
I pass the witness, Your Honor.
Great.
I have no questions for the witness, Your Honor.
Okay, anything else from the state?
State rest, Your Honor.
All right. Mr. Briggs, anything from the defense?
No, Your Honor.
Okay, does your client want a chance to speak?
I believe he probably does, Judge, although I don't know that he wants to speak to the issue of his medication, but
Don't worry about it, Mr. Briggs. Let me do the talking. All right?
All right, Mr. Quintanilla, let me ask.
I'm sorry. Go ahead, Your Honor.
Do you swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. And you understand, sir, that this is not, you can put your hand down. Thank you.
Oh, well, you swear me in, aren't you? Aren't you, sir? Aren't you swearing me in?
All right, sir. You understand that this is not a hearing about the various criminal charges.
This is a trial, isn't it, sir?
You're facing. No, it's not a trial.
Well, you're swearing me in. It's a trial, then, isn't it, sir?
It's a hearing.
Then you swear me in, sir?
Whether you should have to take the medication, the medicines the doctors there want to give you.
I haven't taken medication in 4 years, Your Honor. You know that?
Okay.
And if I'm a little, Ms. Your Honor, hold on, please, sir. Let me speak. I'm not speaking my now, sir? Am I?
You're speaking.
All right. Okay, I know I am. Listen, I am a little bit aggressive because I've been under solitary confinement for 5 years, 10 years, Your Honor. That's why I'm a little aggressive. You know that? And I've been what? food. There's audio in the jailhouse where it's supposed to be a jailhouse, county jailhouse. They bring in what? What? State people, federal people. I'm federal. Food thrown on me.
All right, sir. I
Now, that's why I'm a little bit aggressive, because the way I was treated. I'm kind of a little aggressive because what? The way I was treated, just like an animal is teased every day. You understand me, sir?
All right, sir. I understand your position.
I'm not taking any.
All right. I will find that Mr. Quintanilla is suffering from mental health problems and that he's likely to continue to suffer unless the regimen of medication that the psychiatrist wishes to put him under he's compelled to take that, and I will sign the order that's been prepared by the state. All right. Ms. Quintanilla, I hope you get yourself healed up there. See you when you get back to Floresville.
Thank you, Your Honor. May the doctor be excused.
Yes, thank you.
Thank you.
And
Thank
Your
you,
Honor,
Judge.
are we going to set a monitor return date on him?
Do we already have one?
I don't think we do, Your Honor.
Yes, we should have one. I thought this was just an additional hearing for medication after he'd been sent off. All right, Angel Rodriguez, no, I'm sorry. Bird versus Sparkle Car Washes.
Yes, sir, I'm here. Paul Lawrence for Sparkle and Coleman.
Okay.
And Your Honor, Mark Taylor here on behalf of Mr. Bird, the plaintiff.
Okay, and do the attorneys have copies of whatever documents I need to look at, or do I need to look at anything?
Really, no, Your Honor. It's just the motion and response have been filed. There's no evidence to put on today.
Okay. All right, let me grab that file. Hold on.
I can, Your Honor, I can send you the motion if you'd like.
I think I have a hard copy if you'll hold on.
Okay.
All right, go ahead, sir.
Thank you, Your Honor. Your Honor, Mark Taylor here on behalf of Randall Bird, the plaintiff. Your Honor, this is the second motion to compel that we filed in this case. We had a hearing back in November, early November, on our first motion to compel. And the circumstances of that were it had been over a month since the defendant's responses were due to discovery. Shortly before that hearing, they filed their responses to the discovery request and served some documents. We believe that the production was incomplete and had the hearing. The court ordered that they produce all additional documents. And if they did so within 5 business days, the court would waive the $1,000 in attorney's fees that was awarded. And what happened after that, Your Honor, is instead of really producing anything new, they simply repackaged the same documents they'd produced to us before and supplied those to us. And so nothing new has been provided. I can't tell for certain, Your Honor, if everything has been produced, but I can tell you there are certainly 2 categories of documents that we know have not been produced. One is documents relating to an August 2015 transaction when an individual named Ms. Beatrice Perez was appointed as a representative to handle business matters in Mexico. And the second was a transaction in November of 2015 when certain debt and a lien on property in Mexico was transferred to a governmental entity by the Colemans called the Overseas Private Investment Corporation. This case, Your Honor, involves a dispute over property in Mexico. It involves a settlement agreement that relates to the transfer of shares in a Mexican corporation. And so the transactions that occurred in Mexico in August of 2015 and November of 2015, which directly relate to the property in Mexico, are important for this litigation. And it is inconceivable to me that there are no, that the defendants do not have any documents relating to those transactions. They don't have any emails relating to those transactions. They don't have any correspondence relating to those transactions. That apparently is a position that they're taking today. So we'd like to move forward with this litigation. We'd like to be able to depose the defendants. But at this point, we're not even sure we have all the documents, and we certainly know that we don't have the documents relating to these transactions. So, Your Honor, we request two things. One, that these documents be ordered to be produced. Two, that we received the $1,000 from the last hearing that the court ordered to be paid if they didn't produce all the documents. And three, that we received compensation both in terms of a sanction for the failure to produce documents and for our time here today and getting ready for this hearing in the amount of $5,000. And Your Honor, I know that's a large amount, but it's we keep having to come back to court when we shouldn't have to come back to court. And I keep having to ask the judge to require the defendants to do things that they should be doing without court intervention. So, Your Honor, that's what we're seeking today, the production of the documents that, at least in these categories, there may be more, and we'll just have to figure that out during the course of depositions. But before I start these depositions, we need to get at least these two categories of documents that have not been produced and recover our attorney's fees. Thank you, Your Honor.
All right, Mr. Lawrence.
Yes, Your Honor. Your Honor, I did not appear at that first hearing, and it wasn't because I was flouting the disregard of flouting the court notice or the notice from counsel. I was under a quarantine and I was not able to appear. My office is very small, but we're full of a lot of older folks. I tried to produce all of the documents that I had. Mr. Taylor furnished me with a copy of the court's order. I went back and there were several boxes of hard copy documents that I thought possibly were relevant, and I went ahead and copied it and amended it. So there have been a lot of documents produced. We don't have the particular documents. First I've ever heard of them was today. I did not know there was some particular document he wanted, but we produced all of the documents that we have. And so I guess we could proceed with the depositions if that's what he wants. I have, I don't, the attorney's fees, I don't think are appropriate in the case. I don't think they were appropriate the first time I had filed a motion for continuance. It was my understanding that it would be reset. So I apologize to the court for not appearing. I don't think attorney's fees are appropriate, but if the court wants to stick with the $1,000 fee, I would just ask that it be taxed as cost of court. That'll be all I have on it.
Your Honor, may I respond briefly?
Yes.
Again, Mark Taylor on behalf of Mr. Byrd. First of all, with respect to these documents, Your Honor, these transactions are specifically referenced in our petition. I've asked Mr. Lawrence to provide them to me in emails, and they're specifically referenced in our motion, our second motion to compel. So it is not believable that he hasn't heard about these document requests before today. They're in the papers, have been filed with the court from day one. Secondly, Your Honor, with respect to the last hearing, I put this in the, I really don't want to cast aspersions at Mr. Lawrence about whether or not he was under restrictions or not. I spoke to Mr. Lawrence the day before the hearing, and he was in his office. The day of the hearing, I don't know why he didn't appear. I called his office at the court's request during that, and they simply said that he wasn't available. He could have appeared for the last hearing by video. And so I don't want
no motion to set that aside or anything. So
no, there was not, Your Honor. And so I really don't want to, rehash what happened in the last hearing, but it's incorrect that I did something wrong with respect to that hearing, Your Honor.
All right, Mr. Lawrence, what efforts have you made to, you said you have boxes of documents. When did you receive those?
I'm sorry?
When did you receive those?
I think that it was around the 1st of October.
Okay.
And I started going through them. I mean, I think they were estimated to be 5,000 pages. I went through and we made a very specific response and provided them on USB drives. And we produced all that we had. And understand, Your Honor, this case started in 2005. This was supposed to be a confidential settlement that was made in 2015, but instead it is now before this court in a public forum. That's not before the court today, but I just make note of it, that it is very old And there may be documents, they may have existed, but we don't have them now. And if he has copies, or if he says that somebody else signed a document, I guess we can go to them.
Well, Your Honor, we have documents going back to 2010 and earlier. We have documents after 2015. It is rather odd that these specific documents from 2015 are suddenly missing when the other documents are available and have been produced.
And Mr. Lawrence, what communication have you had with your clients since the motions to compel have started asking if there are additional documents?
Your Honor, the communications that I've had are with Russell Coleman. Russell Coleman is individually named, and he was the president of the general partner in the LLC, which is out of business and has been out of business. I think the articles of dissolution were filed in 2015. I'm not sure. Mr. Taylor might be able to correct me on that, but it was a long time ago.
All right. So what communication have you had with your client since the motions to compel started, asking if there aren't additional documents?
Telephone communications, Your Honor. And yeah, that might have been a Zoom, but I've talked to him more than once.
And have you inquired about whether there are any additional documents?
I have. And he says this is all we have, all he has.
All right, Mr. Taylor?
Your Honor, again, we can take depositions, and if he wants to tell me there are no documents, he can tell me there are no documents. But again, these were very specific transactions. I would like them at a minimum to say they've looked for these specific documents and say under oath that they don't have these documents, because once again, I find it incredible that they would have documents all around this time frame, but they can't find any documents that relate to the August 2015 transaction and November 2015 transaction.
Okay, all right. I will order the plaintiff to produce a specific list of the documents that he wants within 3 days. And then Mr. Lawrence will have a week to get his client to sign an affidavit that says he's searched for those documents and here's what he found, or that he has nothing. And it also says who, to the defendant, Mr. Coleman's knowledge, who else, what other party or individual might have copies of those documents and their contact information.
All right, Your Honor.
And I will hold the request for additional attorney's fees until we make sure that that's been replied to. And I don't know if there is anything, Mr. Taylor, if that comes back nothing, then I guess you'll have to wait and see what they say in their deposition.
Certainly, Your Honor, I understand your ruling, and we'll get that we'll file that with the court and get it to Mr. Lawrence promptly.
All right. Thank you, sir.
Thank you, Your Honor.
Thank you, Your Honor.
May we be excused, Your Honor?
Yes, you're excused.
Thank you.
All right, in the matter of the marriage of Hernandez and Pia. Okay, are you Cindy Hernandez? All right, yeah, your phone is muted.
Sorry.
Okay.
Is it, can you hear me now?
Yes, okay.
Okay.
All right, so let me go and pull this file. 2010-678. Give me just a moment.
Mm-hmm.
All right, ma'am, it looks like you had tried to do this case by submission, and what I came back and said was that this was not guideline child support, and I wanted to have a hearing on it.
Okay.
So let me ask, first of all, has there been a previous case involving you and your husband where child support was set?
No.
Give me just a moment.
Mhm.
Now, there is a green card in the file.
Mm-hmm.
That's addressed to you.
Yes, that was just for proof that I had sent it, because when I went off the checklist, I think it asked for me to send a file of my petition to the Attorney General.
Okay,
So that was just,
all right. And where is Mr. Hernandez?
Mr. Heya, he's on, I don't know.
I'm sorry.
Yeah, Anselmo. Anselmo, ¿nos escuchas?
Is he on the Galaxy A20? What name does it have?
Oh, Jose Hernandez. Yeah, I see him online. Chimpo, tu micrófono está desactivado.
Okay, and why does it say Jose Hernandez?
Because he's using his somebody else's laptop. It's no se escucha. Anselmo.
All right, he has it.
¿Sí
All
me
right.
escucha ahora?
Okay. Yeah.
All right, and Mr. Hia, do you speak the English language?
And I just it's a little bit and speak a little bit too.
Okay. All right, would you be? All right. All right,
Judge,
sir.
I'm gonna have a Spanish interpreter on the 10th. If we want to reset it, they're supposed to.
Okay. All right, let's reset this for the 10th to make sure that Mr. Hia knows what's going on. So we're going to reset this for Wednesday, the 10th. And Mr. Hernandez, I'm going to ask you to get Mr. Hia a copy of the Zoom link. And you can get that from the coordinator. We'll send you both of you actually, we'll try to send you the Zoom link in a chat, I believe.
Yes, I can post that in the chat, Judge. And if I have his email, I could certainly send it to him as well. If Cindy can post that.
All right,
I
I will
have
see
his-
you all on Wednesday. All right, in the matter of the marriage of Fletcher. Let me look at this.
Judge, is Lisa Voigt posted her court date?
I have no idea.
No, she did. She posted in chat. She wants to know if her and her client can be excused.
Yes, always.
Okay.
All right, can everybody hear me now?
Yes, sir. Hold on just a moment.
Awesome. Okay, cool.
Mr. Fletcher, would you raise your right hand?
Yes, sir.
Do you swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, and your name?
Ken Aaron Fletcher.
All right, Mr. Fletcher, please remove your hat in court.
Yes, sir. And Mr. Keith Johansson told me to let you know that he said hi. Mr. Keith Johansson.
All right.
So
thank you.
He just told me whenever I talk to you, let you know. So okay. So, anyways.
And you're married to Erica Garcia?
Yes, sir.
Okay. And has the marriage between the two of you become undermined due to a discord or conflict of personalities?
I would say so. There's no reconciliation whatsoever. She was cheating on me, and ended up getting pregnant.
The yes is all
Oh,
you,
yes.
because you
Okay,
haven't,
sorry.
you didn't file
All right.
for, you didn't file for divorce for cause. All right, sir. And prior to the time you filed this lawsuit, had you been a resident of Texas for 6 months and of Wilson County for 90 days?
Yes, sir.
All right. When did you and Erica Garcia marry?
It was April 26th, 2014.
Okay. All right. So Ember Rose Fletcher was born prior to the date of the marriage?
Yes, before.
Okay. And was there an attorney general's case that established paternity between you and Ember Rose Fletcher?
No.
Okay. And since the date of your marriage, has your wife had given birth to any children other than Mark Fletcher?
Yes.
And who are they?
That is in which I have asked her to change the name, but it was Amy Ray Fletcher. That paternity test was taken and it was not my child.
Okay. And is there a final order in a AG's Attorney General's case or something like that showing you're not the child, the father of the child?
No, we haven't set up any kind of Attorney General anything because she had the DNA test done separately and never got it done on myself. Got it done on the father and it came back positive. So there was never a DNA test done on me.
All right, Mr. Fletcher, what I have to tell you is the law in Texas presumes that you are the father of that child. Now, we can overcome that presumption. It also would presume that you're the father of any child that your wife might be pregnant with when you get divorced. So that presumption may be overcome, but it takes some work to do that. And there's various ways that can be done. There's a acknowledgement that would be signed by yourself, your wife, and the biological father that would show that child is not your child. You can also have genetic testing, if it's done to the standards that is required by the family code, performed and admitted into evidence in this case. And if that happens, then you could be excluded as the father of the child,
Okay.
and the district judge could find that you're not the father of the child. But in the absence of that, I'm not able to proceed today because you saying that there's a DNA test floating around, it would have to be a DNA test done to you also.
Okay, so I need a DNA test done to me, even though, because I can present.
No, sir, listen to me. It's a lot more complicated than that. You can't just wander into court with a DNA test. If there's not an attorney general's case or some other final lawsuit that says you're not the father of the child, you're going to have to file an amended petition that says you're asking the judge to find that you're not the father of this child.
Okay.
Okay. And then you're going to have to get the information from you have to get the genetic testing done and you have to have that admitted into evidence so that you can overcome the presumption that you're the father of that child.
Okay.
Or you can get the form, or you or your wife could go through the attorney general's office because they have a form that they use quite often where the husband, the biological father, and the wife all sign off saying that the husband's not the father of the child. But in the absence of one of those two things, I would have to enter a judgment that says you're the father of that child.
Okay. I am able to submit to the court before 1 o'clock, before the end of the day, that existing DNA test. But
No,
like you
sir,
were
that's
saying, sir, I gotta
that's
go
not. that's not good enough because the law requires everybody to be tested. It could be that the DNA test on the other person is with your identical twin brother. And that,
Okay.
and that, so we not only need a test
Yeah, no.
that we don't necessarily even need a test that says who the father is. What we really need is a test that says you're excluded and that you can't possibly be the father of that child.
Okay. Alrighty, sir. In which manner do I obtain the form from? Do I go on the online?
Mr. Fletcher,
to Attorney General?
you can look online. I can't be your attorney in that. I can just tell you that's the sort of thing that you're going to need. So you may need to hire an attorney to do this, but otherwise you're going to need to follow back up and get that done. Now, let me ask you also, what's going on with Erica Garcia that you have her paying $20 a month in child support?
She does not work as of right now. She doesn't have a actual paycheck paying job. So I was
I
like,
understand,
okay.
sir, but if that was a legally valid reason not to pay child support, there'd be a lot fewer child support enforcement cases.
Yes, sir. I understand. And we agreed upon it.
All right. Well, let me ask you this. Are your children on any kind of public relief right now? Or
No.
are they on AFDC, food stamps, Medicaid?
No, I've tried to get a hold of that, but to no avail. I wasn't able to get through. Now, Erica is holding insurance over them through Medicaid. So they're on her Medicaid.
All right. And you really need to talk to the Attorney General's Child Support Division, because I believe you're going to find that it depends on what kind of aid, and they change the rules all the time. There's a number of different kinds of aid that if you apply for, you're signing over to the state your right to receive child support. Okay. All right. So you may not have the ability, the two of you together, as long as the children are on public aid, to make an agreement that says the child support is going to be that little. So again, you would need to speak with the Attorney General's office about that.
Okay, so I need to speak
Because
to
one of
them
the things that
about-
you signed in the petition and said that there's no other case involving your children, and that may be correct, but usually the Attorney General's office will go in and bring one. Usually if people are asking for aid, unless they just, find that both the parents don't have enough money. But I really would need more information.
Okay. Well, yeah. Well, the whole reason behind the $20 is in my previous marriage. I had her.
All right, and Ms.
pay
Fletcher,
$20
you don't have
so
to
she
go into
could
that right now.
sign the papers.
I'm just telling you that that's the sort of thing you would need to work on before you come back into court.
Okay. When do you propose I
I
come
don't
back into
propose
court?
anything, sir, because you're going to have to get those things done. There's no sense setting a court date.
Okay.
And it may be that if you talk to your wife, that it may be that they've already gone and you would have had to be a party to the lawsuit, but she may be contemplating doing this already. But you're going to need to talk with her because and see if she's already done any of these things. And then also look at the family code. I can't tell you, when I was in private practice for the last 18 years, I was in private practice. I was unable to do cases where the Attorney General was on the other side. So I never went through the hoops as an attorney of getting the genetic testing done. And I'm not sure if it can be different genetic tests. It may be. By that, I mean, I'm sure that you're going to be able to just go and get yourself tested. I think you're probably going to have yourself tested with that other child.
Yes. Okay. And I did bring that up initially, and they took it upon themselves to get this test done. So,
all right. And again, Mr. Fletcher, but you're going to have it to where it's admissible in court, and you're going to have to amend your petition to say that you want the court to find that you're not the father of that child and any other child that may be born that your wife may be pregnant with.
okay.
All right.
Okay. So, as soon as I file or get all this together, go ahead and contact your office again or the county clerk's office to
Well,
reschedule.
it's the court coordinator's office, sir. But again, you're going to have to get that worked out. Yes, once you have everything completed correctly, but it needs to be done correctly or you won't be able to get through again. The last thing I need to ask you is this house that you have mentioned in your divorce decree, was that purchased during the marriage?
House?
There's some address in Lavernia that says that you have to stay at that address.
No, so this is actually Keith Johansson's rental property.
It's a rent house.
And
Okay,
so,
all right.
Yes,
That's fine.
yeah.
Okay.
And
that's
the
fine.
only other property that I have is that auto loan.
Okay.
And yeah.
All right, that's fine, sir.
Okay, so the paperwork you are needing to see would be talk to the Attorney General, get whatever documents needed.
Well, just make sure because there's no sense, because they're going to be coming in, filing something to get possibly see if they're going to be coming in seeking support because your children are on Medicaid. Okay.
Okay.
And you also need to make sure that your decree orders that however insurance is going to be taken care of, including if it's Medicaid. All right. So I wish you good luck with that, sir.
All right, sir. Thank you very much.
All right. What announcements do we have on our criminal cases? Let me go back through. What pleas or anything do we have? And then we'll do the habeas corpus. I just want to see what we got lined up.
Judge, just to notify Aaron Richard Tyler.
Judge, if I may.
Move it to 222, despite the fact he hadn't shown. He's working and he got caught apparently on a long haul trip. That's probably going to be a pretrial diversion. And so we just imagine we'll report to the court on 222 what's going on.
Okay.
Judge, if I may.
Okay, who's talking?
Ruben Flores.
All right, because it was strange. I would see your mouth, but the little yellow box would come up around Mr. Briggs. Yes, Mr. Flores.
Yes, Judge, I have, excuse me, Richard Quintero. He's going to be opportunity to sign the paperwork until this morning. So I didn't know if we could get the next available date for the plea because he would have to drive back.
Oh, okay. And Mr. Flores, you weren't here when I called the docket for all the attorneys. I don't know what other judges do. Well, right now, I want to change this as rapidly as possible and be holding jury trials and hold everybody's feet to the fire. But for right now, when we're not doing that, I don't want to hear about it unless y'all have a dispute. If there's a coordinator is giving you a date and you want that date, and as a defense counsel and the state's not objecting because you're having a hearing and their witness isn't available or for some other reason, then it's a done deal. Just post to me in chat, cause number, name, date, in that order, nothing else, without long explanations like see that I have in my chat this morning. Okay, so what pleas are we going to have?
Your Honor, I believe Mr. On the first page, 1901-29, Tristan Humphus was supposed to be a plea.
Right.
Yes. Do you know is Mr. Humphus to plead? Do we know what's going on there?
You cut out Lorena, but it's not going to be a plea, so I need to reset it.
Okay, so do we have any pleas this morning?
I believe our other plea, Your Honor, was a failure to appear.
Yes, and I just got off the phone with her and she said that she would log in, but she's still not here. So we'll just FTA, I suppose.
Yeah, well, I mean, and she's gonna need to be at probation too, if she's entering a plea.
Yes, sir.
Okay, all right, well, let me look at the material I downloaded on our habeas corpus. Okay, in the lock bomb, is it?
It is.
Lock.
Yes, Your Honor.
Are both sides ready?
State's ready, Judge.
All right.
Is ready.
And let me look at the state's motion for extension. Okay, are either side expecting to put on live testimony?
Not from state, Judge.
Not from the defense.
All right, so do you have an agreement as to the timeline?
I think we're agreed on the timeline, Judge. Basically what happened is this office became aware of Mr. Lockbaum in December, right around the 30th day that he was incarcerated. The form of notice was a pro se petition for habeas that he had written himself. It had been forwarded to us, although if my memory serves, it had been rejected by the clerk's office. In that notice, while Mr. Lockbaum says he's illegally detained, no part of it mentioned that he was wanted for extradition out of Tennessee. Later, when we became aware of it, we notified the court that we needed extradition. We've been working with the Tennessee prosecuting agency, and our understanding is that the Texas governor now has a petition for warrant, and they're supposed to get it to us by Wednesday or Thursday. They're going to overnight it. We've been talking with Ms. Starling. She spoke to her client on Thursday, filed this habeas, and part of this habeas we understand is that there was another arrest in Bexar County, which they claim was on the same warrant. We're unaware of that. We only had Friday to try to figure that out. Bexar County is looking at it. And so that's number one, why we're asking to have a hearing on everything on Friday. And the second part of it is that looking at both the petitioner's habeas writ under 5113, which is the Uniform Extradition Act, Section 17, it does allow this court to extend it 60 days from the original 30 days, which ended in December. And there's no limit on when they can do that. It says they may set bail or they may extend it another 60 days. There's nothing prohibiting the time, Judge, nor that it may be applied retroactively. So that's why we ask that he be kept detained until Friday, Monday being the last day of the 90 days. However, I understand the court is closed on Monday. And so that's why we're asking for an extension to 90 days, Judge. And that's why we're asking we hear everything on Friday.
Okay, well, I mean, the courthouse is closed. We could have a hearing if we needed to.
Sure. In any event, Judge, I think we will have everything by Friday.
Okay, and all right, and who's I mean, I know we want to know the answer, but whose responsibility is it to dispose of the issue of whether there's been an arrest previously here in Texas on the same request for extradition or the same Tennessee warrants?
Judge, I don't have any problem showing what happened. Just the timing of it left us with one day to try to find out. Our investigators immediately made contact with Bexar County. They're searching their documents so we can determine what the nature of the arrest was. We simply don't have that information as of 9 o'clock this morning.
Ms. Starling?
Your Honor, as far as the particular issue under 5108 is concerned, him being arrested on the same charge twice in violation of 5108, I would submit to the court that the state of Texas is the state of Texas. I was not able as a defense attorney to obtain the warrant in Bexar County, but I gave the state in Wilson County as much information I could. I even got the particular warrant number associated, and I put that in my habeas petition. That's the extent that I could find that information from the jail. That took me about an hour on Friday, but the state of Texas shares information with itself. And so it's their responsibility to show this court that he hasn't been arrested for the same charge twice in violation of the Texas Code of Criminal Procedure. And then I have arguments on the other issues as well, Judge, when you're ready to proceed on those.
All right, go ahead.
I first want to address the state's complaint that they didn't receive notice until approximately day 29 of Mr. Lockbaum's incarceration. Article
And
50.
I agree that doesn't, I mean, that may show that the individual officers of the state weren't neglectful of their duty, but it doesn't change the defendant's role.
Thank you, Your Honor. And neither does them using due diligence or this being a complicated issue. Now, Mr. Lockbaum on day 30 or before, under 5113 section 15, was supposed to be brought in either discharged or recommitted. I have no information of either of those proceedings occurring, whether Mr. Lockbaum was discharged or recommitted by a magistrate or another judge. And if he wasn't, I would say his incarceration from day 31 onward was in violation of his constitutional rights. I have not received any information from the state saying that he had been recommitted. Also, Your Honor, as far as, let me go over here, 511317, the court is not required to hold Mr. Lockbaum for 90 days. He has been in custody for 83 days as of right now. The governor of Tennessee didn't even bother signing the requisition until January 25th. He was sitting in the Wilson County Jail costing the Wilson County taxpayers money for over 60 days before the governor of Tennessee even sent the requisition over. Now, when they sent the requisition over, it's my understanding that they didn't even properly send it to the district attorney's office. They sent plain copies, not certified copies, and the requisition itself is not enough, as the court knows. What is also needed, and what's more important, is the governor's warrant, because without a governor's warrant, my client at the absolute maximum cannot be held beyond February 15th. And that is made abundantly clear in the case law that I presented to the court. And I also wanted to once again cite the ex parte Wiener case, which states in the footnote that our legislature has mandated the release of any fugitive confined for more than 90 days, but not arrested pursuant to a warrant issued by the governor of Texas. Now, I understand that the state believes that possibly maybe the governor will issue a warrant by Wednesday, but it's not as simple as just signing a piece of paper. The governor's office is supposed to go through a thorough examination and decide if the application is actually in accordance to section 5113, or else we're going to end up having another hearing all over again because the governor's warrant may not be valid. This habeas is solely for the discharge of my client. This habeas is not pursuant to 5113 section 10, because my client isn't even entitled to make a habeas under 5113 section 10 because no governor's warrant has been issued. And to have him locked up for an additional 7 days when he wasn't even recommitted after 30 is a gross violation of his rights, Your Honor. And we ask that he be released today. And there's no harm to the state by doing this, I'd also like to point out, because once a governor's warrant issues, whether it's Wednesday, whether it's a month from now, whether it's a year from now, that warrant is a valid warrant. But my client cannot be arrested on subject to 5108. He can't be arrested on the same fugitive warrant again and again and again and again. But once the governor actually issues a warrant, that warrant is valid. So the state harmed. If the governor decides that the application is proper and actually issues a warrant, then he is subject to arrest on these charges. But the governor didn't do that in 2019 when he was arrested in Bexar County, and he hasn't done it now 83 days later. And so to leave Mr. Lockbaum in jail on the hope that the governor of Texas will get a warrant, I don't see the point of costing the taxpayers further money, of putting Mr. Lockbaum further at risk, because every single person in the jail right now is a risk to the community. He should be able to go home, and if the governor issues a warrant, then he'll have a valid warrant for this extradition that we know will be valid, subject to his habeas request under Section 10. But until then, Your Honor, it's unconstitutional for him to be held.
All right, Mr. Leday.
And Judge, just again, 5113, Section 17 allows this court today to decide whether he should be held in custody or whether he should be released. It's allowed to hold him to his 90 days. Obviously, when you're talking about a prosecuting agency in Tennessee, the governor of Tennessee, the governor of Texas, and all the paperwork that has to be filed, it's a lengthy process, Judge. And we've been in contact with the governor's office in Tennessee and Texas. Their representation is that we will have it in hand before Friday. And because of the nature of this case, that it is a case he ran from Tennessee, we think he is a flight risk, and we'd like to hold him to Friday and have a hearing on the merits on everything, Judge.
Your Honor, addressing him being a flight risk, I don't understand how that can be the case when he's been in Texas since at least November 2019. He didn't leave after he was released from Bexar County, right? Less than 30 days is my understanding after his arrest, because he was released on that. The governor of Tennessee could have pursued the governor of Texas's warrant back then. Mr. Lockbaum knew that, and it wasn't the case, and he's still in the area.
I don't have any evidence before me of what that previous warrant of whatever nature that was served on Mr. Lockbaum was.
And I tried, Your Honor, but they won't give me that information. I mean, the Bexar County Jail, which is an entity of the state, will not provide that to me because I'm not his counsel of record on a 2019 case.
Okay, well.
And Judge, again, that's something we're actively working on. And why we're pushing it to Friday. I mean, obviously, this is serious enough for them to want to extradite them. I think when we make this decision, we certainly would like to do it with all information present. Ms. Starling got that information from her client. I have no idea if it's right. And we've had 1 day to work on it. So we would like to do it Friday. It's 5 business days. I don't think that's too much to ask given the nature of the case.
What has been asked of my client already is 83 days, Your Honor. And so I would say 5 additional days is a lot to ask.
All right. And what would the hearing be on Friday?
That'd be at your discretion, Judge.
I know what will we be deciding on? What needs to be decided on Friday?
Well, we'll decide, number one, Ms. Starling's contention that he's already been arrested, and we'll have information on what the nature of that arrest is. We will have the governor's warrant, and then it'll be up to Ms. Starling to how she wants to choose to oppose it, whether it's mistaken identity. We don't know, Judge. But certainly we will be prepared to prove that he is the person in question. He is wanted for a failure to appear out of Tennessee, and that we've done all we've.
That would be under something further down than 5113, right?
He's referring to 5113 Section 10, Your Honor, which is the habeas opposing the governor's warrant. Okay. However, he wants the additional days as well because my claim under 5108 will be moot once the governor's warrant issues. There's case law that says that. And so if he anticipates having a governor's warrant, my claim under 5108 is moot. But what I don't understand is how he can guarantee this court that he'll have a governor's warrant by Friday
And
from the
just
governor of Texas.
anything. That's the representations made to me. I'm making no guarantees of that. If that is not true, then on Friday, Mr. Lockbaum will walk. That's the information we have. I realize the state technically is a same entity. However, in practice, that is not the case. We're working with things outside our control. There will be consequences for the state if we cannot have it by Friday, and we understand that. But that's the representations being made to me and what I'm representing to the court.
This court could give Mr. Lockbaum a PR bond and require him to appear on Friday if the court would be open to doing that, but to leave him under incarceration when he's been incarcerated for so long. And again, Your Honor, I have not received any information from the state that he was ever recommitted as required by Section 15.
Okay, and what's the consequences if he wasn't?
I couldn't find any specific case. I'm sorry.
The consequences on this hearing.
So I couldn't find any specific case law on the consequences of that, but it's clear, Your Honor, that that is the process that's supposed to occur. 30 days, he's supposed to be either discharged or, let me find the language.
No, I understand.
I'd say technically he's not being held.
What happened when he was taken in front of the magistrate to see if he was going to waive extradition? I've still never heard when that happened, so I assume that it's because it has not.
November 17th. On November 17th, he was brought before a magistrate and was subject to confinement for the initial 30 days under Section 15. But before the 30 days ends, there was supposed to be a recommitment or a discharge, and neither of those, to my knowledge, it didn't happen. Which I would say if he hasn't been recommitted, then technically he's being held unconstitutionally.
Okay. All right, and what time would the attorneys be available on Friday?
Judge, we'll be here all day, so we're available at the discretion of the court.
All right, Ms. Starling?
If I may have one moment, Your Honor. I only have something at 1:30 at the moment.
I will. Give me a moment.
And to be, I'll ask after.
Just a moment. All right, I will. I'll grant the state's motion under section 17 of
5113, Judge.
5113, but I'm going to, and that would be through, and it's the 12th or the 15th? The 15th?
The 15th
of February.
Okay. For the purposes of this order, it'll be through 11:59 p.m. on February 15th, but I will set this case for hearing at 9 a.m. on the 12th. And my assumption is, this is not a capital murder he's charged with. The governor's office isn't going to be working over the holiday weekend to crank out an arrest warrant. So if it's not available by Friday, he will be released on Friday. And I will also instruct both the attorneys, the state's going to continue looking at the question of whether he'd been previously arrested on this same extradition attempt out of Tennessee and here in Texas and discharged on that incarceration somehow. And if the answer to that is yes, I want the attorneys to let me know that immediately. And unless the state is bringing forth an argument that there's some other reason that it wasn't for all the charges or something like that, that wouldn't be preclude the state from having a second bite at the apple, then I will sign an order discharging Mr. Lockbaum immediately if that's what it turns out that had happened, because I would agree with Ms. Starling that if the state had just quit before in the middle of the process, that their timeline would have run back then. And if they get the governor's warrant eventually, then we can look at the governor's warrant and he can be arrested on that.
Very good, Judge.
And then we can see if it's valid.
I have a question, Your Honor.
Yes, ma'am.
Could I have an order directing the sheriff of Wilson County to provide me with the warrant that he was arrested on? Because my understanding is they don't even have the warrant that he was arrested on. But I want to confirm, and I want to see it. If I can get it from them, maybe I can convince someone at Bear County to let me see theirs.
Sure. Now, I don't know how that works, I have to tell you. I mean, a lot of things these days are electronically or are done electronically, and it's a little, 3 lines of print on a teletype sort of machine that they have there at dispatch and not necessarily some signed and sealed document from Tennessee. But yes, I'll let Mr. Leday or Ms. Whitney look at it. But no, I'll be glad to sign that.
Okay, thank you.
Okay. All right.
Did you say 9 o'clock, Judge, on that one for Friday?
Yes.
Thank you.
And is the court denying my request for a PR bond until Friday?
Yes. They'll either have be a governor's warrant and we can start that procedure though, or he'll be released on Friday. And if it turns out that the state's already arrested and released him, discharged him on this, then he'll be released before then. Excuse me. And has the state had a chance to visit with the new administration at the jail?
We have, Judge.
Okay. All right. So what do we have next?
Judge, may I approach briefly?
Yes.
Judge, I just want to inform the court that Mr. Royce Smith and Mr. Sean McHazlett, who did not announce at 9 o'clock, have made an appearance. They're on right now. I've conferred with the state and we've got reset dates on those two.
Okay. Yes, I had them down as being present.
Awesome. Thank you. Mr. Smith, Mr. McHazlett, y'all are excused until April 13th. Thank
Judge, may I
Your
approach?
Honor.
All right.
Your Honor.
I got 2 people talking. Okay, who's first? Mr. Cedios?
Zachary Hyman is present. Zachary, would you announce yourself?
Sorry, yes, I'm here. I apologize.
And Judge, I conferred with the state and your coordinator, and we've got a date of April 13th for him.
Okay. If you would post that to me in the cause number, name, date format, I would appreciate it.
Okay.
All right. So do we need to start going through the docket? What's going on?
Judge, I have Miss Anzaldo here. She did appear. She was set for a plea. She just cannot get anybody to watch her children right now. Her 2 closest family members are just very sick. And so I'm not sure how we want to handle a plea at this time. Miss Anzaldo, will you please announce?
Okay, I see her. All right, we can reset this for Wednesday.
Okay.
I'm here, sorry.
And Ms. Anzaldo, judge says that he's agreeing to a reset for Wednesday, but you need to find childcare. You have to report to the probation department for this plea, ma'am.
Yes, I understand.
All right, and was she going into custody or going on probation or deferred or?
It's a deferred probation, Judge.
And Your Honor, we don't have a link for Wednesday. Do I just need to get that from Atascosa or?
Yeah, I hadn't looked at the docket. We set somebody else for Wednesday, but was that a civil case? That was a civil case. Never.
That was a civil case, Your Honor.
Okay.
The next date is the 16th, Judge.
Okay, we can move it to the 16th. That's fine.
Okay. Thank you, Your Honor. Thank you, Ms. Whitney.
Thank you.
Judge, if I may.
Yes, sir.
On first case on top of page 4 of the criminal docket, Angie Ford was not logged in when you called the docket, but she is logged in now. Ms. Ford, can you please speak up and let the judge know you're here?
Yes, sir, I'm here.
All right. Yes, and I saw her come in once, but it said Angie Ford. She had to get back off, I guess. All right, I'll mark her present.
And we're going to reset her to 222. I'll post it in chat.
All right, thank you. All right, so it looks like no pleas at all today.
I don't believe so, Your Honor. I believe our pleas have fallen through today for today.
All right. Okay, I have not been doing the resets as we go along. Do you want me to do that? Do you want to we can just start? Tell me what's going on.
We can, Your Honor. We can go over the docket.
Okay, Micaiah Kenton.
Is reset to 413, Your Honor.
Okay. Quintanilla.
Miss Cindy, I was confused. Were we setting it to 6-1 or 6-7 to monitor?
6-1 was the date you and I had discussed, since he is due, that his 6 months time ends at the very beginning of June. And then Mr. Briggs posted 6-7 that he got from Lori. I don't know.
I didn't think there was a June 1 date, but I didn't realize there was a holiday on the 31st. So June 1 does work. I apologize for that.
Okay, so then we're going to go with 6-1 monitor return.
Yes.
Okay. Humphus.
I do not, Miss Andy?
Your Honor, I'm gonna need a reset date. The 16th is gonna be too soon, Lorena. Let me get with the coordinator.
Well, then I'm good with 222.
Okay, that's fine then.
Okay, so 222.
Yes, Your Honor.
Early.
I have done the dismissal, Your Honor. I'm getting ready to file it.
All right. Dotson.
I have 413.
Okay.
All right. Talamantes.
413.
Shower.
I don't have anything for that one, Judge.
I have 413 on Mr. Shower, Your Honor.
Julio Salazar,
We're still conferring, Judge.
Christopher Ward.
I have nothing for that one.
Do
I
you-
have nothing. I do not eat. I don't even know if Mr. Ward showed in court this morning, Your Honor.
Yes, he did show up here in court, and Mr. Kelly did post a pretrial date of 4/13. It was way up at the top, but he did post.
All right.
Yeah, it was the very first post that was done.
Okay, White,
I have 4/13, Your Honor.
Mayeen,
4/13 as well.
Gonzalvo, did that person appear?
Yes, Your Honor, she did, and we reset to 2/16 to plea.
That is correct.
Oh, that was the lady we just talked to, wasn't it?
Yes, Your Honor.
Arroyo,
I have as a no-show.
Mathewson,
Reset to 3/3.
3-3,
Or 3/3.
3-2.
3/2.
3-2. All right, and what was shower 4/13?
Yes, sir.
Ford 2/16? No,
4/22, Your Honor.
Abe Herrera,
I do not have anything, Your Honor.
okay, he was present. Have we heard from Mr. Cabanas?
No, sir, we have tried reaching him and don't have an answer yet,
All right,
but his client is here in our lobby.
all right, I'll put attorney no show. Need to hear from him. Tyler,
Is reset to 2/22 to plea, Your Honor.
Hyman,
I believe I saw him.
4/13, he did appear. 4/13 is
Yes.
the date.
4/13.
Norval Lynn,
Reset to 4/13.
hold on, this thing's jammed up. Royce Smith,
4/13, Your Honor.
Jose Barrientos,
Here in our lobby, and we have heard from Michael Baird, Your Honor. Judge Ellison has not excused him yet, so he said he will appear as soon as Judge Ellison excuses him.
okay, Austin Bess,
4/13, Your Honor.
Sergio Diaz,
Reset to 3/2 to plea.
McCaslett,
4/13, Your Honor.
Davis,
Reset to 3/2.
Gonzalez,
Reset, excuse me, to 2/22.
Pedrosa,
4/13,
Quintero.
2/16 to plea.
Okay, and who is at the jail in custody?
Who is in custody, Your Honor?
Well, we've got somebody at the, it says WCSO.
They were there because we have a couple of people on the docket that are in custody, just in case we needed conference with attorneys and because of the extradition case.
Okay. All right, so Mr. Gear was still waiting to talk to someone, was he? Or to confer with his,
Julio Salazar at the jail, yes. Is this Julio Salazar at the jail right now?
Yes, Julio Salazar, yes.
Okay, thank you. Can you put us in a breakout room?
Yes, I'm gonna put you on breakout room 7, okay?
Thank you, Laura.
okay. All right, Mr. Cedillos?
Yes.
Would you check the format you sent your chat message in and redo it?
Okay.
All right. If somebody from the state wants to hang out, let me go and see, is there anything left on the civil side? Oh, we
I'll
still
stay.
have the people that wanted an hour.
I'll stay and monitor, Judge.
All right. All right. And all right, Ms. Lopez, Mr. Byrd, did y'all come to an agreement?
I think, Judge, they're still in a breakout room. So they're still discussing the case.
Oh, there they are.
And what happened to the Angel Rodriguez case with Alamo Renovations? I missed that one. I'm sorry, Judge.
I need to look at their proposed default, but I
Okay.
didn't want to. I always want to take my time on those and not be rushed. Okay, I'm going to join that and tell them that we're about ready to take off. We'll take a 15-minute break. We'll come back. Let's call it 11:20.
Your Honor, we did hear from Mr. Cabañas's office. Ms. Bryan called there, and he is also with Judge Ellison's court.
Okay. Sounds good. I'll be right back. Okay, the attorneys in the civil case that were still left, they think they have a Rule 11 agreement. They're working on that. They're going to come back out and say they need a hearing if they need something going on. And I'm not anticipating that, so we have 115 for the civil case in Karnes County. The attorney's still conferring for, who is it, Mr. Gear? And then we're waiting for Alfonso Cabanas and Mr. Baird.
Yes, we're still waiting on those two. Mr. Gear has posted a date for Julio Salazar of 4/13/21.
Okay, all right, well, I'm going to work on my judges queue and things like that. Oh, there's Mr. Bird back. Let's make sure. Yes, sir.
I guess I can still say good morning, Your Honor. We're trying to upload the signed Rule 11 right now, so as we discussed.
And Your Honor, I'm still working on the proposed order for the Sheriff of Wilson County. Do you want me to put that in the chat, or has Mark logged off and you want me to put that through him and then email it?
No, he and Ms. Whitney are still online.
Oh, okay. I'm almost done. If I can put it in the chat and then he can make suggestions to me.
If you want to email that to me, that's fine.
Okay, perfect. Give me about 5 more minutes.
Are my two people still sitting in the lobby?
Okay, the Rule 11 agreement came through fine.
Well, that's great, Your Honor. You don't need then the email?
No, this will do it. Well, it could let me sign. Here we are. Okay, I will get this to the district clerk, to Ms. Kruger in just a moment.
Is there a reset date or anything on that, Judge?
No, we're going to mediation, Cindy, on the 11th of March.
Thank you.
Yes, thank you. And will we be receiving a copy through e-filing from the district clerk, Your Honor?
See Ms. Kruger?
Yes,
it looks
yes,
like. Okay, yes,
Thank you.
Thank you, Your Honor. May we be excused?
certainly. Have a good day.
Thank
too,
you.
sir.
You too. Bye-bye.
Bye-bye.
Okay, Ms. Kruger, I just posted that Rule 11 agreement to you.
I see it, Judge. I'm going to download it and get it filed.
Okay, all right. I will be working on stuff here, waiting on the 115 in cars.
Okay.
Why did he want to be here? Because he has to meet the probation. And Zolta asked us for probation. She can bring the
Cindy or Lori, whenever a judge is ready, me and Mark just have a short issue for the order I prepared.
Okay, so you need, there's the judge.
Mr. Lede?
Judge, I'm in receipt of Ms. Starling's proposed order. Everything looks great. Our only two objections was the things requested. The third thing was a catch-all, kind of anything not asked for but related we want. I certainly understand that, but I think that's a little overbroad for us to comply with. And the second thing was asking the sheriff to have it ready by 5 o'clock today. It's already lunch, so I don't even know if anybody's going to receive it till 1. We would ask that it be the deadline be tomorrow. Other than that, we have no objection.
All right, Ms. Starling?
For some reason, Your Honor, it's preventing me from putting into the chat. It's blocking the file. But the reason I have the catch-all in there is because the sheriff is obviously not an attorney, and so I made some very specific requests regarding the warrant or screenshots of their system. But perhaps there's something I'm just not asking for because it's not very common that attorneys ask for the actual warrant. And so since he's in a better position to know what's responsive to my request than I am, that is why I had that catch-all phrase. And I don't think it's overly burdensome. He can't have that many documents in relation to this warrant, I would think. And then as far as today, my understanding is that the court said that if I can show Mr. Lockbaum is being held pursuant to the same warrant or the same charge that he was held in Bexar County, that the court would find that this was in violation of 5108. And because of that, and because of his incarceration for the last 83 days, I don't think by 5 o'clock is an unreasonable request.
Oh. Let me see the language. I'll give them until noon tomorrow, but
Mark, is there any way that you can add it to the chat?
you understand that there's been a change in sheriffs and there's been a lot of change in the high administration. So it's not going to be somebody, I don't think, going back to remember what did I do in November, whatever. It's going to be somebody who wasn't there in November, trying to find out what somebody who's no longer there did in November. So it may take longer.
Judge, I just emailed you the proposed order and I included Ms. Starling on the email.
Thank you.
And was Mr. Lockbaum only arrested on the Tennessee warrant? Was there something else?
I believe it
is
was
not.
the warrant, Judge.
I'm sorry?
I believe it was only on the Tennessee warrant.
That is my understanding in both Bexar County and in here. It's my understanding he's never been arrested for an offense committed in Texas. That would change the analysis significantly.
Give me just a moment to save this. So what kind of tree is that? A lock bomb? Is that a larch or?
I have no idea, Judge.
Okay, so send this to Ms. Sawyer's because it's criminal related, even if it's technically civil. Okay, I sent that, I signed, I changed it, signed it, sent it to Ms. Sawyer's. Okay,
And just clear, that's noon tomorrow. And what about plus number 3, the kind of catch-all language?
you'll see how I edited the language.
Okay, thank you.
And is there anything I need to do, Judge, to get that over to the sheriff, or it's being taken care of?
I talked to the clerk's office about that. I have no idea.
Sounds good. I will do that. Thank you.
And Cindy, could you send me a copy of the signed order?
Yeah,
Yes, yeah, and Mark, it was dropped into
just posted
everyone.
it.
You can actually
It won't
download
be-
it. It didn't come directly to me.
Okay, thank you, ma'am.
I sent it to you in chat first, and then I sent it to everyone a minute later.
Yes, yes, I see that.
Oh, so Mr. Cabañas is out of Lynn's court, but he's not in mine.
Yes, that's what Jennifer says, is that he logged out of there, said he had another court to go to, but he has not shown up here.
Okay. Well, Mondays are busy. All right, I will be here.
Okay, thank you.
thank you, Judge. May I be excused?
Yes, ma'am.
Thank you.
Mark,
Ma'am.
on the one that we had that was a nice size, 20-05-081, I visited with the judge on that one. We're going to reset that one for 222, and I'm going to mail another letter. The notice we mailed out to that person, as I looked in their file, went to the wrong town and was returned to us. So he may not have known he needed to be here.
That's fine. And what was the defendant's name?
It's Jose Arroyo.
Perfect. Okay.
All right, thank you.
Cindy, what was that cause number on that one?
Lori, it is 20-05-081. So 222 is the date.
222. 81. Okay, Jose Arroyo. 222, you said?
Yes. And we haven't gotten the hearing notices yet from Jennifer for that court date.
Okay.
So if y'all have one prepared, then I can send that to him if she's done one for that date.
Okay, so you need the reset dates for the 222 court date?
Yes, the reset letter, yes.
Reset letter?
Right. If she has one. We've gotten the letters for the 216 date, but we haven't received anything for the 222 date.
Okay. She's been out the last couple of days, so I'll check with her.
Okay, thank you.
Thank you. Cindy, we're just pending Abe had another case with Cabanas and then Jose Barrientos with Michael Baird. Are those the two cases? Or have you heard anything on those?
We have checked on those and have not heard anything from the attorneys. Judge is asking that the clients wait here a little while since both attorneys have checked in with us. So I've asked them to wait here in our lobby.
Thank you.
Okay, let me ask the attorneys on the Apperson case. Are any of y'all listening? No, okay.
Your Honor, this is
Oh,
John
there's recording.
Morris. Mr. Waymaker stepped out, but I can go grab him.
No, I thought Corey said that it was motion for partial summary judgment number 8.
8 was the one, I'm sorry, Your Honor.
Which one are we starting with?
We're starting with number 1 and we're doing 1, 3, 5, and 7 today.
Okay.
8 was the one that you granted a week
Already.
ago.
Okay. Good, because I could not find a link to motion for summary judgment number 8. So that was the one on limitations. Okay, all right. I'll start reading on these. Thank you.
Did our link to the documents work, Your Honor?
Yes, this one worked great.
Okay, thank you.
Okay, thanks, sir. All right, Lachey, whatever happens with the attorneys, they're not going to be coming back and doing pleas, so you're welcome to just take off until 1:15.
Okay, repeat that.
Even if we get the attorneys, Baird and Cabanas in here, we're not going to be doing pleas or anything on their clients, so we won't need a record, so you're welcome to take off. I told the Kearns case to be back at 1:15, so.
Okay, Judge.
Take off
Also,
until
may I have the link to that Apperson case?
Oh, sure. I will.
That'll help me.
All right, should have just gone through.
Okay, thanks. 1:15?
Yes, ma'am.
Okay, thank you.
Test, test.
Okay, I'm gonna step away for a minute. I'm gonna run to the store, but I will be back before 1:15.
Same here, Judge.
Okay.
Thank you.
Marty, can you hear me?
Yes, sir, I can.
Thank you.
I can.
All right. Mr. Baird here?
No, sir, we have not heard back from Michael Baird again.
All right, how about Mr. Cabanas?
I see he's logged on, Judge.
I'm here, Judge.
All right, what's going on with your case, sir?
Nothing, Judge, other than we just need a trial setting.
Okay, and where have you been?
I've been in Atascosa, Kamau, and now you're a court, Judge.
Okay, sir. And do you need to confer with your client at all?
No, Judge, I visited with him before.
And when do you want this reset for?
For a trial setting, Judge, whenever that may be.
All right, well, I'll let you get online with the coordinator's office and get that ironed out.
Okay.
Okay, are we ready to start on the Apperson case?
Yes, Your Honor.
Yes, Your Honor.
All right. And I did not open it. I believe I was sent an email with a letter, which I assume is what order these are going to be done in?
Yes, Your Honor.
All right. Well, I had it a moment ago. Okay. Okay. All right. And even though it's motion for summary judgment, I take it someone's requesting a record?
Yes, Your Honor. The defendants are requesting a record, Your Honor.
Okay. All right. Does everyone want to go ahead and Ms. Greenmeyer is here, and we will go ahead and announce just so it's verbalized on the record that you're here and ready to perform, go?
Yes, Your Honor. Corey Waymeyer, joined by John Ellis and Catherine Mallon in my office. We're here on behalf of the defendants DDR Gaddy and Stephen Bressler as trustee, and we're ready.
Marty Truss, on behalf of EOG Resources as a co-movant, we are present and ready, Your Honor.
Your Honor, Blue Hyatt here on behalf of defendant Calf Creek Royalty. Also a joint movement here and prepared and ready, Your Honor.
Your Honor, Kerry Ellison on behalf of the Gun J4 Family Limited Partnership and Gun B Family Limited Partnership. We have joined in these motions and are ready.
Your Honor, Alfred Allen on behalf of Sierra Bank trustee. We're ready.
Your Honor, Robert Kiefer on behalf of MAP 2009. Okay, we are also joint movements and we are ready to proceed. And Brad Williams of MAP is here as an observer.
Your Honor, this is Mariana Rutledge with Porter Hedges on behalf of defendant Kansas Daly, and we're also here ready to proceed.
Your Honor, Christopher Knob, present on behalf of Michael Frells as trustee for the Frells Trust. We're present and ready.
Your Honor, Nirav Patel and Bob Grable here from the Kelly Hart Law Firm on behalf of Cirrus Minerals and Mustang Minerals. We are ready to proceed.
Okay.
Robin Lindley, Lindley, on behalf of defendant PEP 2 Management. We're here ready to proceed.
Your Honor, Doug Kilday, along with my colleagues, John McFarland, Mary Keeney, and Marianne Nitch on behalf of the plaintiffs, and we're ready to proceed on these interrelated motions for summary judgment filed by the defendants and by plaintiffs.
All right, and I think the defendants are going first, so Mr. Waymire.
Thank you, Your Honor. As a housekeeping matter, we did file some quite lengthy written objections with request for ruling timely before 9 o'clock commencement today to the evidence offered by plaintiffs. If it pleases the court, it might make more sense to actually, argue those at the conclusion once Your Honor's had an opportunity to kind of marshal out the elements and motions and issue and kind of what we need to do there. But I'm happy to take it in whatever order pleases the court.
That's fine because I did not get a chance to review the objections.
Very good. And Your Honor, may I share screen and use
Yes.
PowerPoint presentation?
Yes.
Your Honor, we're here today on a traditional motion for partial summary judgment filed by the collective defendant group. The issue in the first motion for traditional summary judgment concerns the release of the Frells lease in the year 1997, and that by releasing that, it terminated participation in the 64 Schnitz-Rydell unit, thus independently causing a termination of the term defeasible royalty interests that are claimed by the plaintiffs here. There are a great number of independent reasons that the plaintiff's claims are barred and that the term interests expired long ago, but this presents one discrete reason that alone causes the termination. It's a pure matter of law issue. There's no fact issues on this whatsoever. And in fact, the plaintiffs have moved on the issue as well. I think everybody's in agreement that the issue is ripe and ready for the court's decision. What the plaintiffs tell the court in the response to the motion for summary judgment at page 4 is that the key issue in dispute in this lawsuit is whether the actual demonstrable production from the Frells tract and lands pooled with the Frells tract during the period of 1975 through 2014 operated to perpetuate the term royalty interest that the Frells sold to the plaintiff's predecessors in the early 1960s. They've misstated it. What the plaintiffs had an obligation to do as part of the summary judgment procedure here was to show production paying quantities through the current. And this skips ahead a little bit to our other motions, but I think the court's going to see that the record is utterly devoid of any proof of production or production paying quantities for the period after 2014 to the present, which alone is fatal to everything that the plaintiffs claim here. But the production here had ended long ago because the plaintiffs lacked any production on the actual Frells tract. They argue that pooling with the Frells tract would be sufficient. We have a number of arguments as to why pooling doesn't work, and those are addressed in other motions. But for purposes of today, we're giving them that benefit of the doubt. We're assuming that pooled production with the Frells tract could somehow extend the interest. And this motion demonstrates that even giving them that benefit of the doubt, the interest terminated in 97 with the release of the lease. What Your Honor is looking at right here is the Frells deed. This is a 1945 deed that basically places fee mineral title into the Frells with a reservation that's to John Hancock that's not in issue or material here. With respect to what we're looking at page 4, this is the oil and gas lease that comes about in the year 1956. The pooling of this lease is what we're talking about today, and that's an issue in the motion. And so what happens is that the Frells in the year 1956 sign an oil and gas lease covering the 488 acres, what's been called the Frells tract, to Shell Oil Company. That oil and gas lease had a very important contractual provision that we're going to talk about today. And specifically at subsection 13E, it talked about pooled units. And what the lease said was that a unit may be so established, modified, or dissolved during the life of this lease, but in no event later than 20 years after the date hereof. And so what we know is that the lease was signed in 1956. pooling is a matter of contract under black letter Texas Supreme Court law. You add 20 years to 1956. If you want to have a unit, that has to come and be formed by the year 1976. And on that point, in the plaintiff's responsive papers, they actually describe that clause as quote, unusual. This comes out of page 6 of their responsive papers. And so this is not a boilerplate. This is not promulgated. The plaintiffs in their own papers tell the court that this express contractual prohibition on units after 20 years is unusual in their estimate. These are the source deeds that we're looking at now that the plaintiffs claim through. There's 3 different ones. And so as we look here, this is Exhibit C. This also touches on a different one of our motions, but what's important is that the face of the instrument requires not production with pooled lands to perpetuate, but production and paying quantities from the actual Frells Tract lands. And we've highlighted that. And the term to feasible interest would only continue and dies, reverts, terminates, expires after 15 years after the primary term of 1960. And so that in this case would be by 1975. So every single day after 1975 requires production and paying quantities from the Frells Tract to perpetuate the interest. This is almost identical. This is the second of the source deeds. This one's Exhibit D. The significance here is that with respect to the road tract, the 4.15 acre road tract that the plaintiffs try to rely on via pooling, this deed to Mortimer doesn't even include the road tract. That's the subject of a different motion. We're giving them the benefit of the doubt today, saying, let's just pretend this deed includes the road tract, even though it doesn't. As we look at the next Exhibit E, this is the third of the 3 deeds. Again, just like the first 2, this does not provide for perpetuation by pooling. This provides for perpetuation only by production and paying quantities from the land specifically described in it. We're giving them the benefit of the doubt. We're saying, for purposes of today, that let's just say pooling even perpetuates these, they still cannot show continuous production paying quantities. This deed illustrates exactly the point about description of what lands are going to perpetuate the interest or not. This instrument, this deed was also signed by Ms. Frells in 1962, so it's contemporaneous within just months. This deed is to an unrelated party to the Francas, and it did allow perpetuation by production with pooled lands. And so again, just because it's not material for today, but just because this is contemporaneous and we're setting up the different motions that the court's going to hear about, Ms. Frells knew how to perpetuate the interest by production from pooled lands. She did it in Exhibit 1J. She did not do it in Exhibits C, D, or E, which are the source deeds that these plaintiffs claim through. Let's talk about the production. This is actually an incredibly easy issue for the court because there's only 2 wells in the history of time that we need to talk about. The first well is the Frells well. As we discussed at the last hearing back on January 26th, the Frells well started producing in approximately 1962, and that well was plugged and abandoned in the year 1997, or at least it was shut in and the oil and gas lease released. There's no contesting in this case that the Frells well was located on the Frells Tract. The plaintiffs can point to this well that was producing on the Frells Tract to try to perpetuate their interest. The problem for them is that that well stopped all production in the year 1997. So what do you do in the year 1997? 1997 is the year that's addressed in our motion today. You take a snapshot. You look around the entire Frells Tract in the year 1997 and you say, now that Frells well's gone, is there anything else that can somehow perpetuate these term to feasible interests that hang by this little thread of production? This is the release of oil and gas lease that we've talked about. So when the Frells leased to Shell back in 1956, the successors, Gaddy, got upset because the lease was not being developed properly. It wasn't producing. And so a lawsuit gets filed, and that lawsuit brings about a settlement agreement, and that settlement agreement brings about a complete and utter release of the Frells lease. So as of the year March 1997, not only is there no production off of the Frells Tract, there's also no oil and gas lease in the world covering the Frells Tract. And Exhibit H here shows how, as a matter of law, that well went away. Just for the court's reference here at Exhibit M, this is the settlement agreement, or an excerpt out of the settlement agreement that I mentioned. And later today, we'll talk a little bit about standing at places. And again, here, these alleged term defeasible royalty owners coming around 20 years late want to step in and say, we have standing under the oil and gas lease, or we have standing to fuss about these matters. They had no standing whatsoever. There was two parties to the oil and gas lease, the Frells and Shell. And eventually Carbon succeeded to that. And through this compromise and settlement agreement, all of the parties agreed that the oil and gas lease, the 1956 Frells lease, would go away in its utter entirety and permanently. And what we just looked at the preceding slide was the release filed of record in March of 1997. So what is the motion before the court? Well, it goes to this old 1964 designation of unit. The 1964 designation of unit is what the plaintiffs attempt to point to say that we can look outside of the Frells Tract. We can look at other leases that were pooled with the leases covering Frells Tract, and we can use that production to perpetuate our interest. This is the 1964 designation of unit that the plaintiffs rely on. You can see in the highlighted portion that it includes 1.85 acres of the lease that covered the Frells Road. If we look, and again, we're going to go through the Texas Supreme Court cases, but what's very important about pooling is that pooling is a creature of contract and contract only. And so if you're going to pool, you have to have contractual permission to do it. And if you do it, you have to do it in perfect conformity with the contractual right from the oil and gas lease. The effect, if you don't, is that it's not going to be effective. Just because you receive permission in an oil and gas lease to pool doesn't mean you have to use all of it. And the court has seen many, many examples over the years where an oil and gas operator doesn't use its right to pool everything. It doesn't have to pool everything from the surface all the way to the core of the earth. It doesn't have to pool every single acre. It can pool leases as to only particular depths or geographical boundaries with it. And sometimes the pooling clause says exactly what you have to do and what you can't do. The designation of unit is what comes about when the oil and gas lessee exercises its contractual rights, and it can exercise all of them or some of them. This is how Shell chose to exercise its contractual pooling rights. What Shell said is that we hereby declare that all of said leases as so amended and or ratified, and all royalty, overriding royalty, and all other interests thereunder, insofar as said leases cover and apply to oil to oil in and which may produce and save from the upper Edwards limestone formation under the respective lands covered by said leases within the above described 80-acre pooled unit are hereby pooled and combined to establish an 80-acre unit pooled for oil as to the upper Edwards limestone formation. So we agree that under the oil and gas lease, Shell was granted broad pooling authority. But what we look at Exhibit I is how Shell chose to use it. And so if we can just go back here for one moment, what Shell pooled was not any lands. What Shell chose to pool were the leases, hereby declare that all of said leases as so amended or ratified, and all royalty, overriding royalty, and other interests thereunder, and saved from the upper Edwards. So what we know is they only pooled the leases. They didn't pool quote unquote lands. We know that with respect to royalty and overriding royalty, those are both interests that arise under the oil and gas lease and the leasehold estate associated with the working interest under the oil and gas lease, and all other interests under the oil and gas lease. And it's also further limited to the upper Edwards limestone formation, and it's further limited to only oil wells. That's how Shell chose to exercise its pooling authority, and it was perfectly entitled to do that because it got it done within the 20 years of the 1956 unit. So let's talk about this 1.85 acres. If we look at Exhibit G, Carbon's president, Mr. Bob Brandt, was deposed, and he agreed that obviously the Schnitz-Rydell well is not located on that little 1.85 acre road track. And so we don't have to talk about, you know, did the well possibly hit the road, and was there production from the actual frills? No evidence of that whatsoever. And in fact, the conclusive evidence is to the contrary, that it wasn't on the road. Let's talk about when Carbon takes over in the year 1983, where was that Schnitz-Rydell well producing? Well, it was producing from the right place. Mr. Brandt confirmed that as originally completed by Shell, when Carbon took it over and it was completed, the well bore had perforation solely within the Edwards, yes. And that's not in any contest here. In 1983, when Carbon takes over operatorship of this oil and gas lease from Shell, there's only one well in the world, and that well is producing from the Upper Edwards Limestone Formation, as the designation of pooled unit spoke to, the well needing to produce as oil from the Upper Edwards Limestone Formation. There's another unit that the plaintiffs now point to. This is, you're going to hear about this unit, and this is not the Schnitz-Rydell unit. This is called 80 acre Schnitz et al. Oil unit. What happened here was that outside of the 20-year prohibition on pooling, Shell decided that it wanted to drill a new, recomplete this well to become what would be called the quote Schnitz et al. Oil unit well. And what's in the summary judgment record is that Shell applied for a permit to drill this well. Exhibit 2I out of the plaintiff's evidence is the permit. And that well never got drilled. Exhibit 2K out of the plaintiff's summary judgment evidence shows that the permit to drill the Schnitz et al. Oil unit well expired as of May 20th, 1983. And so the pooled unit designation comes late. It's outside of the 20-year prohibition under the oil and gas lease. It only purported to pool as to the Austin Chalk Formation at precisely the interval of 10,800 feet below the surface, as shown on the Exhibit A. But again, it is tardy. It pertains to a well that was permitted and never drilled. But now the plaintiffs want to point to that designation of unit that was tardy, and we're going to go through the actual evidence, but it's uncontroverted that no one in the entire world ever gave any validity to that designation of unit. Nobody in the entire world purported to operate or pay royalty pursuant to that unit. And in fact, in the deposition of Mr. Brandt, the Exhibit G deposition, those excerpts before the court, he was asked, did y'all ever purport to do anything or give vitality or say this unit was in effect? No. Do you have any evidence that anyone in the world ever even knew about this unit? And the operator of the Schnitz-Rydell well from the year 1983 forward says absolutely not. So I mentioned at the last hearing that Carbon committed felonies by falsely reporting intentionally to the Railroad Commission of Texas operations. What we're looking at here is Exhibit O. This is kind of the first outside the public record evidence that comes about in the deposition of Mr. Brandt, the Carbon president. And what Exhibit O shows is that on March 25th, 1992, Carbon went into the Schnitz-Rydell well without a permit and set a cement plug at 10,790 feet. You can see over at the far left-hand side, about 5 lines up from the bottom, plug at 10,790. And so again, this operation that happens in 1992 required a permit from the Railroad Commission because it was going into a new field. They were now completing into a field and a formation that was not Upper Edwards Lime. What did they actually tell the commission? This is the completion report that Carbon filed with the commission. And you can see at box 12 that they report that the field is the Davy Edwards, Upper Edwards Limestone, and that it's unchanged. And in the remarks, they lied to the commission and told them that it was the same as the original completion filed in December of 1972 by Shell Oil Company. In the sworn deposition of Mr. Brandt, he's testified that that was categorically and absolutely false. that when his man, Mr. Light, signed this thing, that was not correct, that was not true. Obviously, they knew that was not true and that was not the same recompletion from 1972. Now, it remains this way in the public record. So if one goes to the Railroad Commission, or even the Railroad Commission wants to know, where is this Schnitz-Rydell producing? Is it producing from the Upper Edwards Limestone Formation, the way that the 1964 designation of unit says? If they go and look, they're not going to be able to see that. Even as of the year 2009, they couldn't tell. What comes about in 2009 is more fraud out of Carbon. What we're looking at here at Exhibit Q is that what Carbon filed with the commission was an application to recomplete to a formation shallow to the Upper Edwards Limestone Formation. And so what they are pretending to the Railroad Commission, and this is all confirmed by Mr. Brandt's testimony from Carbon, what they're pretending to the Railroad Commission is that they're going to now go in and complete shallower, when in fact that had already happened 17 years earlier in 1992. And you can see that over on the right-hand side in box 30, the 10,500 to 10,640 depths, they're pretending to the commission that they're getting a permit to go in and do that. That's already been done 17 years earlier, and they lied to the commission about it. It wasn't just lying to the commission once. They lied to the commission every single month, because by law, you are required to report to the commission the field from which your production is coming from. And so every single month, they filled out their production reports, lying to the commission about production and disposition volumes, lying to the commission saying that these were coming from the Upper Edwards Limestone Formation, when in fact they were not. These were as to depths that had not been pooled by the 1964 designation of unit. And to the extent anybody would have wanted to go in and form a new designation of unit, the time to do that had long ago passed. They couldn't. Even as of 2009, the public and the Railroad Commission could not have known that the well was in fact producing from a shallower interval, because what the record is here is that even though Carbon went in and filed this application to pretend to do the operations from 17 years later, what's not in the evidence is that they ever went in and filed an actual completion report telling them that it had actually happened. And so if you go look at the commission records, you wouldn't even see as of the year 2009 that they had in fact done this. They just went in and got a permit for it. I mentioned some of Mr. Brandt's testimony to this point. I'm not saying that Mr. Brandt was the one personally who did it, but his company certainly did it and did it knowingly. This comes out of our deposition, our defendant summary judgment exhibit G. These are pages 293 to 295. And we're discussing the W1 form that I just showed the court a moment ago. Is this a form W1 that went to the commission and was received by them on September 18th, 09? Yes. Is it regarding the Schnitz-Rydell well? Yes. Is the recompletion indicated as a wildcat? Yes. And you're seeking to recomplete as an oil or a gas well between 10.5 and 10.640, is that correct? Yes. Isn't it true that at this point in time that you had already recompleted that well between 10.5 and 10.596? Yes. Does this, was that form signed by Mr. Light? That's his landman, yes. Was this filed some 17 years after operations and recompletion had been done at the depths? Apparently so. At page 2, under the remarks at the bottom of the page, it says W1 for recompletion attempt of the Davy Edwards field to the Austin Chalk formation. No field assigned yet to the Austin Chalk recompletion objection. And he was asked, and isn't that totally inaccurate with respect to what's actually being done? And he answers apparently. This is not in contest. The plaintiffs will concede to you that Carbon lied to the Railroad Commission and that in any review of any public records, nobody in the public could have known that after 1992, that well was no longer producing from the Upper Edwards limestone. This is additional testimony from Mr. Brandt. He was asked, you know, after 1992, there was zero production out of the Schnitz-Rydell well deeper than 10,790 feet, correct? He says yes. That's important because as we look at the 82 designation of unit, that is void and unenforceable, is coming 20 years too late. It pooled only precisely the depth of 10,800 feet. It didn't pool 10,790 or anything shallower. It pooled 10,800. And as we know from looking at the dialogue at Exhibit O, there'd been a plug set down, a big concrete plug that eliminated any possibility that that well would have produced from the interval of 10,800 feet. At the next excerpt, he was asked, we have established after 1992, there was never any further production in the Edwards Formation from the Schnitz-Rydell well. Is that correct? He says, I believe that's correct. That's not an issue. I can find that excerpt in evidence at 10 different places in the record here. These plaintiffs agree that after the year 1992, the Schnitz-Rydell well that they want to rely on by virtue of the 1964 designation of unit never produced from the Upper Edwards Limestone Formation ever again. Let's talk about what a royalty owner could have known, because the plaintiffs waved their hand in incredibly cursory fashion over ratification. Royalties were accepted. If the court actually puts the plaintiff to the burden to show where in the summary judgment record royalties were accepted, they don't have any of that evidence. But let's just pretend that the evidence existed, even though it doesn't. Ratification has to be a knowing acceptance, knowing all of the material facts. And what Mr. Brandt, the operator of this well's president, conceded was that nobody could have known unless you were Carbon, who had done the illegal operation. He was asked, so there's not any way that any royalty owner could have known where the production was coming from in order to object, as Mr. Kilday asked about, between 1972, when it was reclassified as a gas well, and 2011, when you finally got a permit to do operations up the hole? Answer, yes. Nobody could have known what was going on in that well. And had the Gaddies, the mineral executives who sued Carbon and got a release of the oil and gas lease that we looked at earlier, if they had known what Carbon was doing, Carbon would have gotten sued twice. At Exhibit K, we looked at this at the last hearing. This was the plaintiffs being told by Carbon back in 2011 that when that Frells lease was released in 1997, your interest terminated. Full stop, you're done. And we're going to show the court the applicable and binding case law now that proves that Carbon was exactly 100% right on that. And again, we're pretending that there was production from the Upper Edwards Limestone Formation that would have been pooled. Everybody in this case will agree and tell you that absolutely there was no pooled Upper Edwards Limestone Formation because Carbon had illegally recompleted shallower and it didn't exist anymore. But let's just pretend it was. The release of the lease utterly makes that go away. The plaintiffs want to rely on this Texas Supreme Court case of Wagner and Brown versus Shepard. And I have no quarrel with the Wagner and Brown versus Shepard's holding. But when you read the case, it doesn't apply in any way, shape, or form to the relief they try to ask for here. And if the court actually reads the case, what the case does is prove that the defendants are entitled to their summary judgment relief. In Wagner and Brown versus Shepard, the court was called upon to analyze the effect of a terminated lease and its effect on the unit. So there was no contest in that case that the lessor party's lease had terminated. And she wants to say that my lease is no longer bound by the pooling, is no longer bound by the unit, and I'm entitled to be paid on an undiluted portion as if no unit existed. And the court noted there that Shepard's lease and the unit agreement pooled certain premises and lands, not just their leased interests. Although Shepard's lease expired, the lands themselves obviously did not. Thus, while termination of Shepard's lease changed who owned the mineral interest in the unit, it did not cause the unit to terminate because it was a pooling of land and not just the leases. And when the leasehold estates terminated, so too did the pool. That does not mean a unit formed by pooling lands must terminate on the same basis as one formed by pooling only leases. So in the Wagner and Brown versus Shepard case, the oil and gas lease permitted, like our oil and gas lease, that Shell could have pooled the oil and gas leases or could have pooled the actual lands, the fee mineral lands. The oil and gas lease gave both Wagner and Brown and Shell that permission. The difference is that in the Wagner and Brown case, what happened there was that when Wagner and Brown filed its designation of pooled unit, it chose to exercise all of that pooling authority and pool the lands as well. That's not what Shell did in our case. I want to, if we go to the next slide here, because this is exactly what the plaintiffs here are doing, is what the Texas Supreme Court in Wagner and Brown versus Shepherd said you can't do. The court noted there that Wagner and Brown, that's the mineral lessee, urged that termination of the lease should never ever terminate a pool, pointing out that pooling benefits mineral owners, the state, and the environment. Shepherd wanted this, the mineral lessor wanted this categorical adoption of a treatise's view that pooling can extend no longer than the lease itself, because a lease grants only the power to pool the leasehold rights. The Texas Supreme Court there, consistent with many of its holdings, says no, this is a matter of contract and it's going to resolve on the matter of contract. And so what the court did there was looked at the actual language of the lease and looked at the actual language of the unit designation and said it has to resolve on the contract. We're not going to do this broad brush categorical declarations. It notes an oil and gas lease in general and pooling clauses in particular are a matter of contract. Just as owners and operators generally must agree to create a pool, they should also be able to agree when one terminates. If the parties want pooling to expire or not upon termination of the lease, they should be able to say that. Here, the leases here allowed the Shepherd tract rather than just the lease to be pooled for purposes, and that is what the unit designation did. As termination of the lease changed none of the lands committed to the unit, we hold that it didn't terminate the unit. We don't hide from this holding. It is exactly this holding that entitles us to our relief, because Shell didn't pool the lands, it pooled only the leases. And so when the lease is terminated and released, obviously the Frells' participation in the Schnitz-Rydell unit also ceases. It says, again, here's the pooling clause out of the Frells' lease. This is at 13A. We don't dispute that it gave Shell the right to pool, quote, any part of said land and of the lease. Shell had the right. But if we look at the designation of unit, Shell, unlike the Wagner and Brown decision, didn't pool the lands. It only pooled the leases. We hereby declare that all of said leases, as so amended and or ratified, and all royalty, override royalty, and all other interests thereunder, that's under the lease, insofar as said leases cover and apply to oil, and in which may be produced and saved from the upper Edwards limestone formation under the respective lands covered by said leases within the above described 80-acre pooled unit are hereby pooled. The plaintiffs point to the language about insofar as they cover and apply to the respective lands. That is not a pooling of the lands. What that is a geographic identification of the leases insofar as they're pooled, and the court doesn't have to take my word for that. The Chieftain case that we've cited says precisely that, and the Chieftain case is utterly indistinguishable from our particular situation. We'll just talk about the 80-acre Schnitz et al. Oil unit that was never, that Carbon testified no one ever paid royalties under, nobody knew about, they never gave any effect to. Plaintiffs point at this thing now. That unit also pooled only leases, not lands. Hereby declare that any of said leases is so amended, supplemented, and or ratified, and all royalties, override royalties, production payments, and all other interests thereunder are hereby pooled. But that pooled was only the leases, not pooled the leases, quote, and lands. The Chieftain case, the plaintiffs, I think, spend one sentence in the entire response. They spend one sentence on this case, and it's mentioned in our reply papers that their characterization of the facts there are 100% and utterly false. What they tell the court in their response is that the reason that this holding came about was because one of the leases prohibited pooling of lands, and that was the result. That is not true, and they know that's not true. This is what the case actually says, and the reason they don't distinguish it is because they can't. What the court there in Chieftain versus Gaster said was that the unit, a pooled unit, was formed in 2010, which it executed various oil and gas leases. The unit was comprised of 56 leases covering 702 acres. These leases are listed in the unit designation, which comprised 56 surface acres, including the unit. The Streeter well was drilled on the unit, but not on the tract. Title to the minerals in tract 17 is divided, with two parties each owning an undivided 1/2. And there's an undivided 1/4 MPRI interest now owned by Chieftain that was carved out of the Live Oak mineral estate. this is a lot of text here, but if the court goes back and looks at this Chieftain case, it is utterly indistinguishable. And just so that the court is perfectly clear on the holding and is not misled by the responsive papers and sees the actual language, the last paragraph there is, the court says here, we do not have similar language. Although the lone oak lease permitted pooling with other lands, just as we have here and just as was in Wagner and Brown, the street or unit designation did not, which is exactly as we have here and is exactly what Wagner and Brown said wasn't the case there. The unit designation provided that the leases, insofar and only insofar as the leases cover the lands described and delineated on exhibits B and C attached, are hereby combined, unitized, and or pooled into a single consolidated pooled unit. Thus, only the leases were combined, not the lands. Chieftain cites to the insofar as language as proof that the unit designation specifically combined the lands as well as the leases. We disagree. The insofar as language acts to limit the portion of the leases included in the unit, not to expand the scope of the leases included in the pooled unit. When the Fourth Court of Appeals gets this case, the Chieftain versus Gastar case has already written the opinion because it's factually and legally indistinguishable from our particular case. And while the plaintiffs want to wave their hand over and say, well, the oil and gas lease permits pooling of leases and lands, the simple fact here is that, unfortunately for them, the unit designation that was filed by Shell didn't. They cannot get away from the language in the Texas Supreme Court case of Wagner and Brown. They can't get away from Chieftain. Then they tried to point to the exhibit, the Frells lease at paragraph 13B language to somehow get around the effect of the release of the lease, ending the Frells lease participation in the unit. What that clause says is that the lessee may dissolve any unit established hereunder by filing for record in the public office where the lease is recorded a declaration to that effect, if at that time no operations are being conducted thereon for unitized minerals. There's no contention here that Shell attempted or Carbon attempted to file a dissolution of unit. There were an aggregate of 3 leases that made up the Schnitz-Rydell unit. And with respect to the other 2 oil and gas leases, those had not terminated. And presumably they continued participating in the Schnitz-Rydell unit. Nobody in the defense group is taking the position that the entire Schnitz-Rydell unit went away when the Frells lease was released. Our position is that as a matter of law, just as the Texas Supreme Court says and Chieftain says, that after the release of the entire lease, that the Frells lease obviously had to stop participating in the unit. The next sentence says, subject to the provisions of the paragraph 13, a unit once established hereunder shall remain in force so long as any lease subject thereto shall remain in force. And again, it is not that it's a complete straw man to say that these defendants are taking the position that the Schnitz-Rydell unit ceased to exist or went away. We do not. The position out of the defendants is that as a matter of black letter law, when the Frells lease went away, it simply stopped participating in the unit, and the Schnitz oil and gas lease lessors and the Rydell oil and gas lease lessors could continue to do whatever they wanted with Carbon. But the Gaddy plaintiff insisted that the Frells lease be returned. So again, the plaintiffs have been absolutely making this case up as they go along. Now they want to say that somehow that since they realize that the designation of unit doesn't help them because it doesn't pool lands and doesn't bring them within Wagner and Brown versus Shepard, and because they know that the Chieftain case is utterly dispositive of what they fuss over here, now they try to say, well, when Shell formed the designation of unit, they filed a P12 with the Railroad Commission of Texas. The P12 is a promulgated form. This is Exhibit 2H in the plaintiff's evidence. It's a promulgated form that under the Texas Administrative Code, every single operator has to file if they have a pooled unit. And so, and it speaks to tracks on the promulgated form. You cannot vary that form. If the plaintiff's contention was correct, there could not have been the resultant Chieftain because every single unit well in the entire state of Texas would necessarily have been pooled on a track basis simply because the promulgated form P12 at the commission says so. But this Nugent versus Freeman case, this is not a remarkable proposition. It was just an easy place to cite to the court. Furthermore, it is the settled law of the state that the rules and regulations of a railroad commission respecting the development of an oil field cannot affect the property rights of the owners of the land or the parties holding the interest thereon. We hold that a pooling or unitization cannot be brought about by an order of the Railroad Commission. So again, in the response papers, and this is addressed thoroughly in the reply, but in the response they go, well, go look at Exhibit 2H. They filed a P12. That makes a pooling of lands. No, that absolutely not the law. That's absurd. And there's piles of cases that say the commission doesn't have jurisdiction over that types of things. Continuing in the make it up as we go along. Now that we read the response, now they say, oh, well, there was a cross conveyance that upon the pooling back in 1964, all of the royalties were cross conveyed. And now we owned under Schnitz Tract, and now we owned under Rydell Tract. That's just categorically wrong. I would note that as they claim to chain out their title, nobody described in their deeds amongst one another the Schnitz Tract. Nobody described in their deeds the Rydell Tract. There was no cross conveyancing here that somehow made them owners under the Schnitz Tract or made them owners under the Rydell Tract. And if they say it too loud, I expect that the owners under the Schnitz and Rydell Tract may have something to say there about slander of title or other things. But here, this case discusses exact language that comes out of our lease that specifically says there is no cross conveyancing here by virtue of the oil and gas lease. It says, moreover, the Puckett's lease specifically states that the entire acreage pooled in a unit shall be treated for all purposes, quote, except the payment of royalties on production from the pooled unit, as if it were included in the lease. The language of the lease shows an express intent not to effect a cross conveyance as to payments of royalties. Our oil and gas lease has the exact same language. If we go to Exhibit B, we're looking at here under subsection 13B of the oil and gas lease. The very first sentence is exactly the phrase that comes out of the Puckett versus First City National of Midland case that says the parties here didn't cross convey anything. They expressly said not. And so to the extent that as the plaintiffs make this up as they go along, they want to say cross conveyance now, that doesn't work. I've mentioned Texas Supreme Court holdings. This is, again, there's piles of these cases that stand for the proposition, but it says oil and gas leases in general and pooling clauses in particular are matters of contract. A lessee's authority to pool requires the lessor's consent, which is typically furnished by a pooling provision in the lease. Pooling is valid only if done in accordance with the method and purposes specified in the lease. A pooled unit that does not comply with the terms of the pooling agreement is invalid and unenforceable absent the lessor's ratification. So the Texas Supreme Court has told us as recently as 2007, if an oil and gas operator like Shell goes out and files the 1980 Schnitz et al. Oil unit, that is outside of the methods and purposes in the lease, and it is invalid and unenforceable absent ratification. Full stop. Well, let's talk about ratification. The plaintiffs waved their hand over ratification. The elements of ratification, I was looking for them, that they speak to, and I've got the, I'm not laying my hands on it right this second, but it is an act with knowledge of all the material facts. Obviously here, there could be no act with knowledge of all the relevant material facts to ratify the 82 unit because Carbon didn't even know, the operator didn't even know about the unit. And two, Carbon was lying to the Railroad Commission and there was no way to discover unless you could physically go crawl down the well bore of the Schnitz-Rydell well to know that they had lied. Again, so to just kind of put a bow around this, the designation of unit was only for the Upper Edwards Limestone Formation in the Schnitz-Rydell unit from 64. We agree that the 64 unit was valid when it was formed, but it was only for the Upper Edwards. And for the pooling to have any effect on any other leases included with it, it would have had to have been from specifically the Upper Edwards. Sunak versus Parks is a Texas Supreme Court case from 1967 that talks about the effect of your operations exceeding what is in the pooling clause. So there's really kind of two different pooling issues here. The first one was the 82. That one is just full stop, void and unenforceable unless ratified. And that's discussed in the Sampson case. And then there's the issue of the 1964 unit and when in 1992, carbon illegally recompletes shallower into a new field without telling anybody and outside of the pooled interval. What Sunak involved was initially there was a completion of a producing oil well on a unit that was authorized for gas only, but not located on the premises. What the Texas Supreme Court there says is our holding is that the first oil and gas lease terminated. The drilling and completion of the particular operation, the oil well, off the premises after the primary term did not end in the production of gas so as to prolong the lease under the 30-day provision. And so basically where it's saying there is that when your actual designation of unit was for gas only, producing oil doesn't do you any good because it's irrelevant. It's not pooled because it's outside of the unit designation. That's no different here, where the unit designation from 1964, a valid unit when formed, describes Upper Edwards only, but after 1992, there's no more production out of the Upper Edwards. Again, here is the confirmation out of Carbon and that all of the parties agreed to here. After 92, there was no more 1964 unit designation production. It stopped. There was no more Edwards production. They had illegally plugged it back. We also know if you wanted to try to use this void 1982 unit that comes too late, that there's no production at the 10,800 foot interval spoken to in it. This is Mr. Brandt saying that at 10,790, there was already a concrete plug set. Exhibit O is this dialogue that shows that there was no production at 10.8. If we go to slide 48, the bottom, this is another one. The court says, since the lands were pooled without authority, the habendum clause cannot be used to extend the term of the lease beyond August 1961, the terminal date of the primary term of the lease. Again, I can give the court piles of authorities that just say, if your production is not within the specifically defined designation of unit, it doesn't help you. It doesn't apply to any other. It's not constructive production anywhere else. It doesn't help these plaintiffs because there was no unit to cover it. Okay, if we go to slide 50, the plaintiffs set up a number of different defenses. They say limitations, they say latches, they say waiver, they say estoppel. None of those help them here. In response to our traditional motion for summary judgment, they would have needed to come to the court and actually prove with evidence, both plead and prove with evidence their defense. But they've got a bigger problem here, is that there's no claim here out of any defendant for them to have a defense to. What they have to do is come in and show production and paying quantities from the year 1975 to present day today. And so they start pointing to all of these invalid, to the void 1982 unit. They point to the 1964 unit where there was no production. So they start pointing around, but none of that works. And so just as a pure fundamental matter of procedure, where no defendant in this case is asking for any affirmative relief here whatsoever, other than attorney's fees as equitable and just under Chapter 37 being the declaratory judgment statute that we got sued under, there's nothing for the plaintiffs to assert a defense to. And this first case speaks to that concretely. They say limitations, that somehow we're barred from coming in to sue to say the 82 unit is invalid. We don't have to sue to say that's invalid. It's invalid full stop, as stated in the Sampson's case, unless we've ratified it knowingly. There's no evidence whatsoever that we've done that. They haven't brought any. And what this Texas Supreme Court case of Morris Buick versus Davis says is that it is the law of this state that where the subject matter of defense interposed by the defendant constitutes an independent cause of action which does not go to the foundation of the plaintiff's demand, it cannot affect a reduction of the amount of the plaintiff's recovery except by way of a set off, and the statutes of limitations are available to the plaintiffs such as defense. On the other hand, if the subject matter of the defense be of an intrinsically defensive nature, which if given effect will operate merely as a negation of the plaintiff's asserted right to recover, or in abatement, either wholly and partially, the amount claimed, the statute of limitations doesn't apply. And so what the plaintiffs have done here is they come 20 years late and they throw the rock and sue all of these 13 defendants. And then they say, even though we can't prove continuous production and paying quantities based on the record title in Karnes County, Texas, you're barred from statute of limitations from responding back about all of these invalid matters. That's not how it works. This is all elements of theirs, and there's no statutes of limitations applicable to us simply defending ourselves against their 20 years tardy claim. Had they asserted a timely claim, we would have been making the exact defenses back at that point in time. Ratification. Here are the elements of ratification. Along with full knowledge of the facts of the earlier act, ratification requires approval by act, word, or conduct with the intention of giving validity to the earlier act. The evidence in this case is completely uncontroverted that all of the material facts were intentionally concealed and lied to by Carbon to the commission. Nobody could have known what Carbon was up to other than Carbon, and it was only discovered in the course of this deposition in this case after the plaintiffs had thrown the rock starting the lawsuit. This comes straight out of the plaintiffs' pleadings. The plaintiffs say that the elements of ratification are approval by act, word, or conduct with full knowledge of the facts of the earlier act and with the intention of giving validity to the earlier act. Again, there's no question here that none of these defendants had any knowledge that Carbon had been lying about where that production was coming from. With respect to the 82 designation of unit, this is the plaintiff's own expert, their title expert. With respect to the designation of pooled paper called the 80 acre Schnitzel oil unit, was there any ratification of that unit? Not of record, no. And that would be with respect to any party in the case, isn't that right? As far as the record in Karnes County, no, sir. Their title expert agreed there was no ratification of that 82 unit. They say waiver. Waiver is defined as an intentional relinquishment of a known right or intentional conduct inconsistent with claiming that right. Again, here, how could any party in the case have known about their rights when Carbon lied to the Railroad Commission under penalty of perjury for decades? Here's estoppel. If we go to the next one, they also say estoppel. Defendants also contend that the trial court erred in rendering a joint and several judgment against Frazier, who did not join in the 66 lease. Plaintiffs say that Frazier, by accepting the benefits of the lease executed by her, became bound by its terms under principles of either ratification or estoppel. We recognize the general rules upon which plaintiff relies, but there can be no ratification or estoppel from acceptance of the benefits by a person who did not have knowledge of all material facts. And that is exactly, again, what we have here. That one doesn't save them. They say laches. They say laches. They don't prove laches. If they had an affirmative defense of laches, they needed to bring it to the court. And that's an unreasonable delay by one having legal or equitable rights and asserting them with a good faith change in position by another to his detriment. They don't even wave their hand over what the good faith change of position by another to his detriment would be out of them. Let's go to slide 58. Consistent with the making it up as they go along, in the responsive papers, they now say, well, the source deeds say they're subject to the Frells lease. And so therefore, we are covered under the lease, we're parties to the lease, and we can assert all of these defenses. This case, Stevenson versus Vineyard, says that's exactly wrong. The term subject to, as used in the mineral deed, has a well-recognized meaning. The word subject to, used in their ordinary sense, means subordinate to, subservient to, or limited by. There is nothing in the use of the words subject to in their ordinary use, which would even hint at the creation of affirmative rights. Subject to, as used in conveyances, is a term of qualification, not of contract. And so in their responsive papers, when they say, well, it says subject to in our source deeds, it says it's subject to this lease of record. Now we have rights under the lease. That's exactly not the law. That is not what subject to means. In this case is a clear example of holding that that's not what it means. And again, on these defenses, this is so intellectually sloppy the way this has been presented. So again, no defendant here is making a claim in any way, shape, or form other than fees under the declaratory judgment statute. And so what would they have a defense to? what they're doing is setting up a hypothetical that doesn't exist of us, the defendant, suing Carbon, and then Carbon asserting a defense to our claims. That's not what has happened here. That's not what's happening here. Carbon and Gaddy and the settlement agreement said, we're done with this lease. The whole lease is gone. All of these defenses that they tried to set up are them stepping into the hypothetical shoes of Carbon and then asserting a hypothetical defense to a hypothetical claim that no defendant in this case has even made. So with respect to the idea of standing, I mean, it's just simply absurd that any of these defenses would apply, period, just as a matter of the posture of the pleadings. Exhibit N is the affidavit of masters. There's been no objection to any of the defendant's summary judgment evidence. All of the summary judgment evidence of the defendants is in at this point. That includes this master's affidavit, which just goes through all of the operational production history that we just talked about. That's all uncontroverted here. Additionally, in the exhibit GG, when they want to point to the, when they want to point to the, when the plaintiffs want to point to the 1982 unit, which speaks to precisely the depth of 10,800 feet, and specifically to Austin Chalk, the uncontroverted exhibit GG affidavit of Gary Gonzenbach, which is one of the defendant's petroleum engineering experts, is that that production is not even from the Chalk. That production is out of the Eagleford, which is another problem under the 1982 unit. In terms of getting even remotely close to a fact issue, I guess that's the closest you would get, but for all the reasons we've talked about, you never even get there. Your Honor, I think I have about 20 more minutes. If I could transition into what that was what we call motion for summary judgment number 1. Numbers 3 and 5 are much quicker, but I don't want to overstay my welcome with the court. If I could,
sorry, I muted myself. Somebody walked in. No, that's great.
Okay. May I have the 1992? This is our third motion for summary judgment, addresses that the Schnitz-Rydell well was not producing from the upper Edwards limestone formation, and so there was no pooled production after the year 1992, even if you wanted to give effect to the unit designation. Here, this is the deposition excerpt from the plaintiff's title expert. He was asked, if you don't have pooled unit production and the production is located off of Frells Track, can you use the production to perpetuate the Frells lease? And he says, if you have a well not on Frells Track and there's no pooling, can you perpetuate the Frells lease? I said, yes. And he says, no. So it's no different here as to these term defeasible royalty interests claimed through the 1960 and 1962 source deeds. If it's not in the, we don't agree that pool production even applies, but if you go that far, it's got to be in the interval. And they say that. This is the Sampson case. We've talked about that one, that a pooled unit that doesn't comply with the terms of the pooling agreement is invalid and unenforceable. This is Bob Brandt. Again, that says, I'm at slides, page 6. After 1992, there was never any further production ever in the Edwards formation. He says that's correct. The Sunak case that we looked at earlier, that one says if your production is not coming from the pool, from exactly what you've pulled, that doesn't extend to any other leases other than the lease where the particular well is located. Exhibit P, this is the oil well completion report in 1992 where Carbon Oil Company lied to the commission. Exhibit O shows that as of 1992, a plug had been set at 10,790. Now, again, just so that we have this in one place on this idea of a ratification or a waiver or a laches or something that any defendant had knowledge of any material facts. This is Bob Brandt. This is the operator of the Schnitz-Rydell well, and he was asked, so there's not any way that any royalty owner could have known where the production was coming from in order to object, as Mr. Kilday asked about, between 1972, when it was reclassified as a gas well, in 2011, when you finally got a permit to do operations of the hole. He says, yes. And again, this is the operator of the well. You don't have to take the defendant's word for it. The operator's telling because they lied that no one could have told. This is the exhibit Q out of the summary judgment evidence. This is the permit that was issued to pretend to do the operations that had already happened back in 1992, 7 years earlier. So again, there's a permit for them, but they never come back and tell the commission they've actually done it, even after lying for 17 years. Again, here's the oil and gas lease. That oil and gas lease gets released in 97. The Frells well, the only well producing on the Frells tract, goes away in 1997. It's plugged. So now the plaintiffs have no production on the Frells tract as of 97 to try to perpetuate their interest by production paying quantities. And if you look around at the only validly formed designation of unit, that's the 1964 unit. That's for the Upper Edwards only. And we know that as a matter of law, there was no Upper Edwards limestone formation. As a matter of law, the third motion for summary judgment requires being granted for the reason that as of 97, even if you didn't adopt motion for summary judgment number 1, that the release of the lease ended any kind of participation. Here, this motion, the third motion, demonstrates conclusively that there was simply no pooled production, period. Under the oil and gas lease, there's a new lease. And this is also material to motion for summary judgment number 1. What the plaintiffs don't tell you, as they try to urge that somehow pooled production continued despite release of the Frells lease, is that there was a brand new lease taken in 2010. It was taken in 2010 because there was no lease on the 4.15 acre road tract. And so the idea that they would be participating under the 1964 designation of unit is utterly absurd, but certainly by 2010, they cannot with a straight face tell you that they were, because there was a brand new oil and gas lease. And what's more, there was a brand new designation of pooled unit. At exhibit DD in the defendant's evidence, this is a brand new unit that covers all depths from the surface to 11,100 feet. What's the significance of that? Well, we know that there could have been nothing whatsoever still participating from the 64 unit or the 82 unit, if you wanted to give vitality to it, even though it was void from its beginning. But the 2010 is a brand new lease, and the 2010 unit's a brand new unit, and none of the plaintiffs ever ratified or accepted royalties or did anything under the new unit to somehow participate in constructive production. This Montgomery versus Rittersbacher case stands for the unremarkable proposition that unless they ratify, there's no pooled production. There's no production in pooled production, period. No participation in pooled production. How do we know they didn't ratify? Well, you can take their expert's word for it. Can you tell the jury about any ratification by any MPRI plaintiff in this case of the oil and gas leases excerpted in items 3 through 5 of your report? The new 2010 to 2014 oil and gas leases with the greater landowner royalty? No, I don't see any ratification. So based on the public records, there was no ratification. And in the response to the defendant's no evidence motion for summary judgment, the plaintiffs now say that the very first ratification that they did came about when they filed their lawsuit in July of 2018. So there was an entire, even under their view of the world, there was an entire 8 years gap between 2010 and 2018 where they had not ratified any kind of a unit. And with respect to the new lease, with the new unit that included leases covering where the Schnitz-Rydell well was, those have been, they never said they wanted to participate in those. Exhibit 52 at page 19 is where they are acknowledging in writing to Carbon. The plaintiffs are saying, hey, what's going on? We've been cut off of royalties as of 2004. Well, that's because their interest terminated in 1997. This is a transcript from the last summary judgment hearing. This is where Mr. Kilday told the court that the record showed Carbon paid royalties to the plaintiffs until at least 2008. The reason they were cut off in 2008 is because their interest had terminated. They did not receive royalty. They cannot say that they ratified the 2010 lease or the 2010 unit designation, the new ones, by accepting royalties, because those had already been long cut off. And here at footnote 4, out of their response to the traditional motions for summary judgment, the 8th motion, again, they reiterate that it had been cut off by 2011 in their actual argument. They said 2008 at any rate. There's a brand new lease comes around in 2010, brand new unit in 2010 that covers it, covers the lease as to that road track. They never ratified it. There's no constructive production, period. I want to talk about the 82 designation of unit very briefly. This is how they open. This is how the plaintiffs open their response. They say that the defendants and their predecessors gladly accepted those royalties and had no complaints about the operation of the various lessee operators until after the suit was filed. What the evidence actually shows is that Carbon got sued for being a bad operator. It wasn't that anybody was gladly accepting royalties, and there's zero evidence of any defendant in this case accepting any royalties. They tell the court that in their MSJs, defendants make an all-out assault on the decades of production from which they or their predecessors received and accepted royalties. There's no all-out assault going on anywhere other than the plaintiffs filing this lawsuit, throwing a rock at a 20-year status quo, seeking to reset $80 million in royalties paid after the year 2014. It's a simple matter. If there was production and paying quantities on the Frells track continuously from 1964 for the plaintiffs to come in and bear their burden and show that. They can't because there wasn't. They want to now rely on the 82 designation of unit that was categorically void and unenforceable on the contractual terms. They say, again, I asked the plaintiff's expert, if you don't have pooled production, if you do not have pooled unit production and the production is located off of Frells track, can you use that production to perpetuate Frells oil and gas lease? And he says, no. Sampson, we've got, if they're going to use the production, if they're going to use production from the Schnitz-Rydell well, it's got to comply with the unit. It's not on the Frells track. We know that. So you look at the contract. If we look at page 7, this is the 20-year limitation. Page 9, this is the 82 unit. There's the recording stamp. It is years too late and unenforceable. With respect to Mr. Starr's testimony, their title expert, he was asked. And so you can tell the jury that with respect to the designation of pooled unit, that would have been outside the contractual pooling authority contained in the Frells lease. And he says, yes, it's outside the 20 years. It absolutely did not.
Was there royalty paid to your predecessors and or to the people who own the, I guess, the reversionary rights and the rest of the mineral rights, the executive rights? Was a royalty paid on the road? Because the 82 attempt to pool is what includes the road, or it tries to include the road?
The 82 unit purported to apply to everything, to Schnitz tract, Rydell tract, and road tract. Okay. But it only spoke to the Austin Chalk formation at precisely 10,800 feet. And so what the uncontroverted evidence in the case is that on the public records, there was no chalk production. There was no production at 10,800 feet. And what Carbon testified to, this is the operator of the Schnitz-Rydell well. That was in the earlier sites. This is in our Exhibit G. He testified that Carbon, the operator, never gave effect to the 82 designation of unit and never paid royalties under the 82 designation of unit. Okay. I can dig that site out, but
that's fine.
Mr. Brandt testified unequivocally they never paid royalty under the 82 unit.
And when was the unit that was designated that included the road? The road, or was there one? It was just
the one that was only the road came about in the year 2010. That was only far more recently.
And was there a production unit that included just the road?
The unit that was it would have been only the road, the Schnitz tract, and the Rydell tract from the surface of the earth to the top of the upper Edwards limestone formation, and that came about in 2010. And there was a unit that was filed in 2010. It was actually the one that's in the summary judgment record was a supplemental a supplemental designation of unit that added that 4.15 acre lease on the road track from Surface to Upper Edwards.
But that was a new lease and not the 56 lease?
Yes, Your Honor, that's exactly correct.
Okay, all right, go ahead.
And the evidence is uncontroverted that none of these plaintiffs ever ratified the 2010 lease or the 2010 unit covering the road. And their expert was asked about that, and he confirmed also that there was no ratification whatsoever of that. And I would point out that the plaintiffs don't even mention, they know this is an independent reason this is all fatal to their claims. They don't even mention the 2010 lease in any of their summary judgment papers. They don't even mention the 2010 unit designation in any of their summary judgment papers. They're playing hide the ball. They want to say that the defendants somehow ratified the designation of unit, the 82, the void one. Again, ratification, this comes straight out of their brief under their elements. The elements of ratification are approval by act, word, or conduct with full knowledge of the facts of the earlier act and with the intention of giving validity to the earlier act. This is this is what's absurd as I talk about them making it up as we go along. This comes out of the plaintiff's fourth amended petition. This is after they've had this lawsuit for over a year. And they tell the court at paragraph 73, in January of 64, Shell and Standard Oil Company of Texas formed a pooled unit containing 80 acres named the Schnitz-Rydell unit. A portion of the Frells tract, the road, is included in the Schnitz-Rydell unit as permitted by the Frells lease. At paragraph 75, production from the Schnitz-Rydell unit included production from the Schnitz-Rydell well. The Schnitz-Rydell well was classified as an oil well, and all production from the Schnitz-Rydell well was treated as production from the Schnitz-Rydell unit at all times from 1964 until the Schnitz-Rydell well ceased to produce in paying or commercial quantities in spring of 14. So the idea that they would have ratified the 82 designation of unit, or that any defendant ratified the 82 designation of unit, the idea that they ratified the 2010, this brand new lease that covers only the 4.15 acre road tract, that or that they ratified the unit. They're telling the court in their fourth amendment petition that the production has at all times since 1964 been out of the Schnitz-Rydell unit that was formed in 64. And that hasn't been the case since at least the year 1992. They did not tell the court in their fourth amendment petition that the production was from the 82 unit. They didn't tell the court that it was from the 2010 unit. Now, again, I just want to, the idea of any ratification here is so absurd. I just want to make sure the court has at least some of the direct, uncontroverted evidence on this thing. Bob Brandt was asked, did you ever receive any lawsuit from any mineral owner or non-participating owner during Carbon's operatorship alleging unitization or communization or any validity to the Exhibit 61 designation unit? This is the 82 unit. No. Are you aware of any party ever during the entire time of Carbon's period of operatorship, any party ever behaving as though we're taking the position that Exhibit 61 was a valid designation of unit? No, this comes straight from the operator. With respect to the public filings, nobody ever said the Schnitz et al. Oil unit was being produced under. These are just examples. All of the filings continued under the old 64 Schnitz-Rydell unit. This is an example. This is Exhibit 2D from 83. In Exhibit 2F, this was filed as recently as 1992. They're still calling it the Schnitz-Rydell unit. They're not proceeding under the 82 Schnitz oil unit because the evidence in the case is that that permit for that well expired. They never did it. In the production reports to the commission, this is Exhibit 2G. They call it the Schnitz-Rydell unit, not the Schnitz et al. Oil unit. Here's more testimony out of the owner of the well, the operator of the well, the operator with the P5 operator with the commission with P4 responsibility for this well. So that I have a clean question. In looking at Exhibit 61, the purported designation of unit filed by Shell, with respect to this designation pooled unit that we looked at, Exhibit 61, during the time that Carbon was operator, you never purported to pay any royalties pursuant to or giving effect to the designation of unit, did you? I don't believe we did. This is the operator with the purse strings stating unequivocally that they did not pay royalties under the 82 unit. Again, this is the citation directly to answer your question earlier. And Mr. Kilday lodged an objection to the form, but they didn't object prior to today's hearing. That evidence is, I don't know what the form objection was, but to the extent he had one, that's waived. Now we talk about what the world could have known. Mr. Brandt, the P4 operator of this well, was asked, so there's not any way that any royalty owner could have known where the production was coming from in order to object when it was reclassified as a gas well in 2011 when you finally get a permit. Yes, he agrees. And this is where he tells you he didn't even know about the 82 designation of unit that now the plaintiffs want to say that he was proceeding on. The plaintiffs are literally stepping into the shoes of Carbon saying, well, they were operating under the 82 unit, of course, even though it was void and unenforceable. Here's where Carbon says, not so. He was asked just briefly, I think the exact question was, did anyone ever complain about Exhibit 61? Yes. You didn't even know about Exhibit 61 before today, and you were the operator of the Snitz Rydell well for decades. Yes. All right, do you have any evidence whatsoever that anyone in the world knew about Exhibit 61? No. So again, I've brought the court this uncontroverted evidence straight from the horse. This is straight from their expert's mouth. This is straight from Carbon. But this is what they tell you in their papers. Moreover, it is not possible to learn definitively at this late date whether plaintiffs or defendants' predecessors consented to what Shell did. That's not true. All of the evidence all of it is completely uncontroverted that even Carbon, the operator of the well, didn't know about this thing. How they can tell the court with a straight face that, quote, it's not possible to learn definitively at this late date whether someone consented to it, that makes zero sense. And it gets more absurd than that. They brought in their first motion for summary judgment that they filed back in April of 2020, they told the court that as a matter of law, ratification has occurred. So we've demonstrated there's no fact issue. They tell you here, well, we can't really prove what the heck happened, but they wasted the court's time. And this is going to be, we will be coming for a request for attorney's fees as are equitable just under Chapter 37. They told the court back in their first motion for summary judgment that this is conclusive against us and ratification happened as a matter of law. This is as we talk about this case being made up as the plaintiffs have gone along, this is the stuff we've been responding to for the last 2.5 years. This goes to the standing. I mentioned earlier that what they want to do is set up a hypothetical where the defendants are the ones asserting a hypothetical claim. We're not as a matter of law. And then they step into the shoes of Carbon and assert hypothetical defenses like ratification, laches, waiver, estoppel. Here, this is out of their response to the traditional motions for summary judgment. They say plaintiffs are neither the same party as Shell Oil, nor are they in any way acting in the same capacity. Shell Oil was the lessee operator of the Frels lease. Plaintiffs' predecessors were merely term royalty owners who had no say in what Shell did or did not do. They got that one right. That is correct. They don't have any standing to step into Carbon's shoes and assert hypothetical defenses to hypothetical claims that don't exist. And so with respect to the 82 designation of unit, it's void. It's late. It's unenforceable. The only way the thing becomes enforceable is if there's ratification. Carbon would have to be the party to show ratification, not these plaintiffs, but in any event, even if they could hypothetically step into that role, they don't establish any of the elements of ratification. And in fact, the conclusive summary judgment evidence is exactly to the contrary. I forgot to mention this in my earlier remarks, but again, in the making it up as they go along, they now say that when that Frels lease was released in 1997, that, well, maybe that would have been a breach of the duty of good faith and fair dealing to the non-executives by the mineral executives. And they cite to Judge Ray's South Texas Outfitters case that Clinton Butler and Tom Joseph tried down there. And so I guess if they felt like a duty had been breached, they could have filed a lawsuit over it at some point in time back in 1997 when the lease was released. I don't think that would have gotten very far for the reason that no mineral executive or predecessor of defendant signed the release of oil and gas lease. The release of oil and gas lease was executed by Carbon and placed of record by Carbon. Nobody signed the thing. But again, if they want to assert, go and sue under the South Texas Outfitters case and assert a claim, I think they're probably going to hear more statute of limitations to that. But that doesn't make any sense either. Your Honor, we would ask that the first and the third and the fifth motions for traditional partial summary judgment be granted for the reason that the 82 designation of unit is void, full stop, is unenforceable, full stop. And under the 64 designation of unit, there was no production under it, full stop. And we know that after the year 1992, there was no production under it. And we know that the Frales well stopped producing in the year 1997 from the Frales tract, so they can't use that one. And independently and additionally, the first motion for summary judgment should be granted because precisely as has been held in the Chieftain case and in perfect accord with the Wagner and Brown versus Shepherd case, here Sheldon pooled the lands. They certainly had the right to. We don't contest that. But just as in Chieftain, they only pooled the leases. And the insofar as covers 80 acres, just like Chieftain said, obviously you have to designate the geographical boundaries of the lease that's being put into the unit. And that's exactly what that was. So all three of the motions are good motions and would ask the court grant those, and they would become part of the package supporting the limitations judgment that is already out there that would go up on appeal.
You're muted, Your Honor. Your Honor, yes.
I'm muted. I'm sorry. Okay. How long do the other defendants think they need?
So this is Marty Truss for EOG, and I need less than 5 minutes.
All right. Let's go ahead and hear from the other defendants, then we'll take a break before we hear from the plaintiff. Let's go ahead, Mr. Truss.
Thank you, Your Honor. So EOG Resources has joined in the motions argued by Mr. Waymeyer, but filed a single issue motion a couple of months before that overlaps largely with DDR Gaddy's first motion for summary judgment. And my point is not to reiterate any of that. Mr. Waymeyer did a great job comprehensively covering all of the legal arguments that we make in our motion. But I do want to point out that the disposition of that motion, it's based on the 1997 release and the effect of that release on plaintiff's claims. The disposition of that motion does not depend on any of the other facts and arguments regarding any alleged fraud of the prior operator, the validity of the units, those sorts of things. So we're not retreating from any of the other arguments we've joined in. I only make the point that analytically, it's a rifle shot argument regarding the effect of the 97 release. And if Your Honor finds that plaintiff's term defeasible royalty interest cannot survive past the 1997 release in accordance with Wagner and Brown and Chieftain, then that's good for EOG's motion as well. Finally, my motion includes, first time in my career, some probably strong criticism or stronger criticism of a Texas Supreme Court case than I've ever put in writing. That was certainly not done to either besmirch the court or necessarily that case. Wagner and Brown is the case, is the law of the land in Texas. Our point there is simply, as I put in my motion, that's not a case that would be prudent to extend. And that's exactly what the plaintiffs are asking you to do in this case, is to extend the holding of Wagner and Brown far beyond the facts, and it was tightly limited to its facts by the Texas Supreme Court and the subsequent Chieftain case. And so the point of the criticism is simply to encourage the court to exercise that holding and apply that holding as narrowly as the Texas Supreme Court did. With that, Your Honor, we ask that the court also grant EOG's motion for summary judgment. That's all I have right now.
Okay. Who else on the defense side? No one? All right. We'll come back at 3 o'clock, and Mr. Kilday, you can start.
Thank you, Your Honor.
Okay. See y'all at 3. Okay, are we ready to go on the plaintiffs?
Yes, Your Honor.
It's in motion. All right. Defense.
Thank you, Your Honor. Just as an initial housekeeping matter, I wanted to just address the format and the order. My understanding from the letter that the defense counsel sent to the court on Friday is that the first motions to be heard would be the defendant's first, third, fifth, and seventh motions, which we've heard from Mr. Waymeyer and Mr. Truss on, and that we would then respond and also present our first and second motions for summary judgment. So we're going to take those up by issue, dealing first with the issues that Mr. Waymeyer discussed last, which are the issues about the 1982 pooled unit for the chalk formation and the production out of the chalk formation. We have a motion on that in our first motion for summary judgment, and I'll be addressing those. Separate issue on the release of the Frells lease in 1997. We want to take that one up next, and my partner Mary Keeney is going to address that issue as part of our first motion for summary judgment and in response to the defendant's first motion for summary judgment. So that's how we intend to proceed on those two issues in this block of time that the court has made available. I did want to raise, there are the seventh motion for summary judgment filed by DDR Gaddy is an incorporation into a motion filed by Sierra Bank and Cyrus Minerals and Mustang Minerals, which is Mr. Allen's clients. And that motion addresses issues that are discussed in the DDR Gaddy third and fifth motions. It also includes a no evidence point, and DDR Gaddy has a no evidence point in their sixth motion, which I believe Mr. Waymeyer wants to take up last. I didn't really hear a no evidence point being urged in Mr. Waymeyer's argument, so I presume that the argument on the no evidence point should be done in connection with the sixth motion by DDR Gaddy. And then similarly, there's a point raised in the Cyrus Minerals Sierra Bank motion at pages 10 to 14 that overlaps DDR Gaddy's second and fourth motions. That issue Mr. Waymeyer did touch on briefly, which was in connection with the argument that the term royalty deeds do not allow for pooling. And so we have arguments on that as well. And my partner, Mr. McFarland, intends to address those issues in connection with the second and fourth motions for summary judgment filed by DDR Gaddy. And with the court's permission, we'll just defer that discussion until we get to that point, I presume tomorrow.
Okay.
Okay, thank you, Your Honor. I want to share screen and address the issues that Mr. Waymeyer discussed last, which relate to the 1982 pooled unit and the production out of the Austin chalk. So can the court see my screen there?
Yes.
Okay, let me get to that. Okay, there we go. Thank you, Your Honor. As noted, we're going to address the third and fifth motions for summary judgment at this time, and the portion of the seventh motion dealing with related issues connected to the third and fifth motions. So this is also in Sierra Bank's motion, and we'll reserve the no evidence point and the issue about perpetuation of term royalties by production in a pooled unit. And I want to just start with just an orientation of undisputed facts, at least undisputed for purposes of this motion and this part of the argument. First of all, for purposes of this argument, the plaintiffs are indeed successors to the term royalties that were granted by Mr. and Mrs. Frells back in 1960 and 1962. I believe the grantor at that time was actually just Mrs. Frells, as Mr. Frells had passed away. But the plaintiffs have put on summary judgment evidence of that in our response to the no evidence motion. But this is just addressing the issues about the chalk unit. The plaintiffs are indeed the successors to those term royalty deeds in the early 1960s. Second of all, this is an undisputed point that the Schnitz-Rydell well did produce oil and or gas from the 1960s until it stopped producing in June of 2014. And there are records in the summary judgment evidence as well of that from the Railroad Commission and from experts. Thirdly, the defendants and their predecessors received and accepted royalties from that production through 2014. And we also do not dispute that after 1992, the production from that well was from the Austin Chalk Formation. It's also undisputed that in 1982, Shell filed a pooled unit designation in the real property records of Karnes County, Texas. That's been in the real property records for going on 39 years now. And in addition, they filed papers with the Railroad Commission addressing their right to pool and filed that. We'll take a look at that. That's undisputed that that's in the Railroad Commission records. They also filed a permit application to recomplete the Schnitz-Rydell well in the Austin Chalk Formation. All of that was in 1982 when Shell was the operator. And it's also undisputed that there's been no claim for alleged breach of the Frells lease by any of the defendants or any of their predecessors. And finally, no defendant and no predecessor of any defendant has ever given notice to the lessee, to either Shell or after Shell to Carbon, that they believe that there was ever a breach of the Frells lease. And we'll see that lease in a little while. There's a requirement in the Frells lease, if there's to be any claim or any contention that there's been a breach of that lease by improper pooling or otherwise, that there needs to be notice given to the lessee in a timely way, with the lessee having a 60-day opportunity to cure the alleged breach. And there's
And
no
your clients benefit from any of that?
Our clients benefit from the production, Your Honor. And so we are claiming, as the records show, as the history indicates, as all party behaved and treated this production over decades, that this production was for the Schnitz-Rydell unit, and it was for the benefit of all participants in that unit, including the owners of the Rydell tract, the owners of the Frells tract, and the term royalty interest owners, which are our clients. So we do benefit from all of that. What's happening in this case is that the defendants are now trying to go back through records and recreate history. They're trying to show that production that was treated as unit production for many decades should now be altered, and that the court should now change that history and say, no, 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 even though we pocketed the royalties, even though we received money and accepted money as unit production for decades, we're now going to go back and say all of that production from 1992 forward, or based on some arguments from 1972 forward, even though we pocketed the royalties, we're going to claim now that was only production for the benefit of the Schnitz tract. It was lease production because that well's located only on the Schnitz tract. And so what I'm just trying to point out in this initial overview orientation is that the history is undisputed, that during the real time, the operator treated it as unit production and the recipients of those royalties treated it as unit production.
Okay.
Does that answer your question?
Not really, but go ahead.
Okay, I'm happy to respond more specifically. If I misunderstood the court, I apologize.
Okay. Your clients weren't parties to the lease.
That's correct.
So
Third-party beneficiaries.
Okay. Are they third-party beneficiaries, or?
We're entitled to be paid royalties under production from that lease and from lands pooled with that lease, because we are term royalty owners. Mrs. Frells sold our client's predecessors interest in the royalty.
Okay, and do you contend that the lease is still in effect?
The 1956 lease, no, Your Honor, that lease is no longer in effect.
Okay.
So just to bring
what could have occurred, and when do you agree with the defendants on when the 1956 lease was terminated?
Yes, Your Honor, and Ms. Keeney will address that in more detail. But yes, there's no question that the lease was released in 1997 at the behest of Mr. Gaddy, who filed a lawsuit complaining about production only from the Frells well. There was no reference in the demands or in the lawsuit about the Schnitz-Rydell well, but he urged a release of the lease, and that lease was indeed released in 1997.
Okay.
But what happened is after that, the production continued. And as the production continued, royalties continued to be paid to the defendants and their predecessors and to the plaintiffs and their predecessors. So the unit remained in effect. And the owners of the Frells Road tract continued to participate in that unit, even in the absence of a lease, as the Wagner versus Brown versus Shepherd expressly makes clear. And Ms. Keeney, again, is going to be the one carrying the water for us on that. But there was still a pooled unit that still continued to produce and pay, and royalties were still paid to the defendants and their predecessors and received and accepted by them. And for many years after 1997, those royalties were still also paid to the term royalty owners, which are our clients and their predecessors.
And when did that stop?
It's not 100% clear, Your Honor. There are various points in time where different term royalty interest owners have indicated that they continue to receive royalties through 2008. I believe there's one that says at least through 2004, but there's not clear records because Carbon, the operator, indicated that they had lost some of their records in some kind of a flooding event. And so we don't have complete records of the payment of those royalties. And as you can tell by the fact that we are representing 25 plaintiffs, these interests have been divided into multiple different fraction portions. And so the amount of the total royalties that were being paid after dividing it into dozens and dozens of different people, some of whom are not parties to this lawsuit, the shares were very small. And so nobody paid a whole lot of attention to this during that time period when it was being produced in what Mr. Brandt testified was paying quantities, but it was very small paying quantities.
All right, go ahead, sir.
Okay, thank you, Your Honor. So just to, again, part of reorienting us, this is the Frells tract that's shown. It's just southeast of Gillette in North Karnes County, and the Schnitz-Rydell unit up in the west side, including a portion of the road. Your Honor asked a question moments ago about which units included parts of the road, and they both did. The 1964 Schnitz-Rydell unit included this 1.85 acre portion of the road and 40 acres of the Schnitz tract, and then 38.15 acres of the Rydell tract. The later 1982 unit included the exact same lands and the exact same tracts in the exact same portions. So both are 80-acre units comprising the same lands and producing from exactly the same well. These are the two wells, Your Honor. We refer to the well over here on the yellow portion that's on the northwest corner of the box part of the Frells tract as the Frells well. It's called the C.W. Frells well #1. In this lawsuit, we've called that the Frells well. And then over here on the left in the Schnitz-Rydell unit on the Schnitz tract, less than 200 feet away from the property line for the Frells tract, that's the Schnitz-Rydell well. And we'll use those terms a lot this week. So the term royalty deeds, these appear in the record as exhibits 1D, 1E, and 1F. There's a 1/4 term royalty interest that was conveyed to Mr. Dan Auld in 1960. That's at exhibit 1D. There's a separate 1/4 term royalty deed to Glenn Mortimer in 1960. That's exhibit 1E. And then there's a third 1/8 term royalty deed given to T.C. Huddle. That's in 1962, and that's at exhibit 1F. Each of these deeds has the same language. They're each for a term of 15 years. And importantly, and as long thereafter as oil, gas, or other minerals, or either of them, is produced or mined from.
Right, and I'm sorry, give me just a moment, please, sir.
Yes.
All right, I'm sorry, go ahead.
Yes, thank you, Your Honor. So these are for a term of 15 years and as long thereafter as oil, gas, or other minerals, or either of them, is produced or mined from the lands described herein in paying or commercial quantities. So that becomes the penultimate question in our case is, was there production in paying quantities? to perpetuate these interests beyond the mid-1970s. So the issues we're going to talk about in this presentation are the production from the Schnitz-Rydell well after 1972. Why 1972? Because the Sierra Bank motion alleges that when that well was reclassified in 1972, that it stopped being unit production. We didn't hear much about that in the oral presentation, but I want to address it because it was part of that motion. And 1972 to 1992, that was a period of time when the Schnitz-Rydell well was reclassified as a gas well at the Railroad Commission. And then after 1992 is the second time period, which we did hear a lot about today. That's when the well had been recompleted to the Austin Chalk formation. We also want to talk about the fact that there was undisputed production from the Frells well until 1997. So during this 20-year period where there's an argument about reclassification as a gas well, during the entirety of that time, there was production from the Frells tract from the other well, from the Frells well. And so for that reason, we believe these arguments about the reclassification are really irrelevant because we had that production from the Frells well, and then the Schnitz-Rydell unit well became reclassified as an oil well in 1992. And then we'll also talk a lot today about the 1982 pooled unit designation. Mr. Waymeyer made some reference to that. That was a pooled unit for the Austin Chalk comprising the exact same 3 tracts that were in the original 1964 pooled unit where the Schnitz-Rydell well produced. And the defendants claimed that that 1982 pooled unit breached the Frells lease. They claim it violated the lease, and they point to paragraph 13E of the lease. Our argument is that those claims and contentions by the defendants are barred. Why are they barred? Well, 3 separate reasons. We've got limitations, and our first motion for summary judgment addresses that, as well as our response to the defendant's motion. Also quasi-estoppel, and also waiver. So those are the things we'll be talking about today. Here's a brief timeline, Your Honor, just to put all this on the map where we can look at it in one place. The first time period I want to flag is 1975 and 1977. That's the expiration of the initial 15-year terms on those 3 deeds. The Auld and Mortimer term royalty deeds expired in 1975. The initial primary term expired in 1975. And then the primary term of the T.C. Huddle deed expired in 1977. So between the mid-70s and the EOG production, which is shown in the record and does appear in all the parties' pleadings as judicial admissions, as well as in Adalia Romanos's affidavit detailing the production from the EOG, that production began in spring of 2014. So is there continuing production between the mid-70s and 2014? That's the test in this lawsuit. And there's 2 wells, as noted. The Frells well produced until 1997. That well was on the Frells tract. It was drilled in 1962. It produced until 1997, and it was plugged at that time. The other well, the Schnitz-Rydell unit well, there's no question that well produced until June of 2014. And that well is on the Schnitz-Rydell unit, less than 200 feet from the Frells tract. It was completed as an oil well, and it was classified as an oil well when it was first completed and drilled. And its first production was in 1963. So from 1972 to 1992, the Schnitz-Rydell well was classified at the Railroad Commission as a gas well. And then in 1992, it became classified again as an oil well when it was recompleted to the Austin Chalk formation. So that's the history that we'll be talking about. These are the time periods. That's when the wells were producing. And that's why we say there was continuous production through 2014, and then by EOG continuing from March of 2014 to the present time. The Schnitz-Rydell well, though, ceased producing in June of 2014. Then it was plugged in 2018. So the defendants are arguing that we've got this production from the Frells well through 1997, but first argument on the reclassification is the Schnitz-Rydell well stopped in 72. Second argument is even if you get to the recompletion in 92, it stopped in 92, and that there's a gap between the end of that production and the EOG production. And so there's no ongoing production to perpetuate the interest. That's the defendant's position. We disagree, and we'll describe why. EOG's position, at least in their initial briefing on their motion for summary judgment, they lay out a sort of a different argument. They go ahead and acknowledge the production through 1997, but say that after 1997, when the Frells lease was released, that this gap can't be carried by ongoing production. So that's the defendant's position on that. But the undisputed facts for purposes of this motion, the Frells and the Schnitz-Rydell wells both continue to produce, and that production continued to be reported to the Railroad Commission as unit production, not as lease production, not just as Schnitz tract production, but as unit production on that Schnitz-Rydell unit. The plaintiffs and their predecessors continue to be paid royalties, and that's in the summary judgment record. Defendants and their pressers continue to be paid royalties as well. And they took no action to dispute or protest anything about these new pooled units, about reclassification, about the formation of the chalk pooled unit in 1982, or otherwise. There was no claim made against the lessee for any of those activities that are now being raised decades later in the course of this lawsuit. Carbon and EOG signed a written agreement that's in the summary judgment record. We'll take a look at that in just a little bit. In 2013, EOG acquired Carbon's position in connection with these leases and in connection with the Schnitz-Rydell unit. And in that agreement, EOG acknowledged in writing and signed it that the production had perpetuated the interests of the Rydells, which required production and paying quantities in order to be perpetuated. And so Carbon and EOG have agreed that this production that we're relying upon perpetuated these interests. The legal issues we'll be talking about is what is the effect of that pooled unit designation in 1982? Is it valid? Is it not valid? Is any argument about invalidity waived or stopped, or are they barred by limitations to challenge that pooled unit designation? And what to do about the untimeliness of raising issues complaining about that pooled unit designation after accepting benefits for decades thereafter. And we'll be talking about—
Let me ask you, Mr. Kilday, would that be your client's relief if we're only talking about your client's ability to be paid royalty prospectively? By that, I mean, if your client's got money and then the predecessors and interest of the defendants just lay behind the log for a few years, and they jumped up and sued your clients and said, hey, we want our money back, our royalties back, and you were unjustly enriched, even though they had known that your client shouldn't have been paid, but for some reason they let it go on. I could absolutely see that be a defense there, but would that transform production that doesn't satisfy the requirements, if it doesn't, to perpetuate the royalty interest into production that perpetuates it?
I believe, if I understand your question correctly, if they were to claim against the plaintiffs that we were unjustly enriched by the payment of royalties during that time period, there is a 4-year statute of limitations to try and reach back and collect wrongfully underpaid royalties. And we talked
right, but I mean, if this came up in 2000,
yeah,
if they waited 3 years and your clients got paid for 3 years and then they suddenly ran in and sued.
I think if the defendants had sued, they would only be entitled to look back 2 years, because that would be a money had and received unjust enrichment claim. But yes, if they were able to satisfy their burden that those royalties should not have been paid to our clients, they could have brought that claim back in 2010 as to royalties between 2008 and 2010. But what we're talking about,
but what I'm asking about is, I would agree with you that in a situation like that, or I don't know, I think that it seems to me impossible, or that in a situation where if the defendants knowingly accepted benefits when there was not production under that would perpetuate the royalty interest your clients had, that might preclude them from being able to get a recovery from your clients and get that money back. But with those defensive measures that your clients could bring against having to repay the money, would that convert production that didn't perpetuate the royalty interest into production that did perpetuate the royalty interest?
Well, what our argument is, Your Honor, is that the complaint about an improper pooling is a complaint that needs to be made against the lessee. And that complaint is governed by the lease, which requires notice and an opportunity to cure. And that was never done. So we contend that any complaint was waived. We contend that any complaint is barred by limitations, and that any complaint about the claim of ongoing royalties is barred by quasi-estoppel because they received and accepted the royalties as unit production. And having accepted those royalties as unit production for decades, it's taking an inconsistent position now to somehow seek to go back and rewrite history and disavow those royalties.
I understand all that, but my question is, are your clients able under the law to claim the benefit of that theory?
Well, yes, Your Honor. Under the theory of equitable quasi-estoppel, they are taking an inconsistent position from the position that they took for decades in receiving those royalties. And we're saying this production was unit production, just as the defendants contended when they were putting the money in their pocket. They also contended this was unit production. And they were.
So I think everybody's in agreement that if this was unit production and the royalty interests were perpetuated by pooled production, I think everybody's in agreement that you win. I may be overstating that. Mr. Wiemeyer, Mr. Frost, am I overstating that?
Your Honor, as I understood you, if the production was unit production and if the term royalties could be perpetuated by unit production, which is something that we conceded and perhaps didn't need to, then I follow you. But both of those are being
I understand you just conceded that for these particular motions.
Your Honor, to answer it, in this case, the Mortimer and the Huddle, two of the three source deeds don't even include the road. So as to that, it wouldn't. And then with respect to it would not just be, and they don't provide for pooling on the deeds to perpetuate. And then third, it would have to be not just production, but production and paying quantities. I don't want to lose sight of that. So I think those would be the three caveats from us.
And Your Honor, as to the road, the Mortimer and the Huddle deeds make clear that they are referring to the same land conveyed by John Hancock Mutual Insurance Company to the Frells in 1945. And so Mr. McFarland will address this in more detail probably tomorrow when this issue comes up on the second and fourth DDR Gaddy motions. But we dispute what Mr. Waymeyer has characterized on those deeds because we believe they do very clearly include the road as part of the Frells tract by incorporating the property description contained within the Hancock deed to the Frells in 1945. But I don't want to get ahead of my skis on that. Mr. McFarland's going to cover that and address that in more detail.
Okay, let me ask this one more way and then I'll let you alone for a while. Okay. We have a situation come up sometimes. I've heard tales about it since I was in high school. I've read case law where this sort of thing happens. All right, what if there was no actual production from the Rydell well? What if carbon was in an even bigger bunch of violators of the law and for some reason having to do with what their royalty interest was or whatever, they were actually siphoning off oil from somewhere else and claiming it was Rydell production and then paying everybody on the Rydell pooled unit. And that went on for years and the defendant's predecessors all knew about it.
Well, it's an interesting question.
But in that case, if obviously the production that wasn't actually on even the pooled unit, that was just being reported as such as a criminal act, I mean, that would not perpetuate the royalty interest, would it?
It's an interesting question that I've not given a lot of thought to. I think one thing that makes it very different is the fact that it's not from any of the tracts that are involved, and that may make it a different case. Here we have production from the tracts that are involved, that are pooled, that had been pooled for many years, and where the prior production history was a known quantity. And so I think where you have still production of oil and or gas coming out of the well, which is coming out from under the reservoir beneath all three of these tracts, and it's being treated as unit production, the fact that all parties were receiving and accepting the royalties does trigger the doctrines that we're talking about here: waiver, quasi-estoppel, and limitations. But I don't know the answer to your question, Your Honor, about whether the same would hold if they were simply taking oil from a different part of the state and reporting it as though it came from this tract. I don't know the answer to that question. I have not researched that.
Okay, and I guess the reason I'm asking that is, again, so are you saying that yes or no, by waiver, by estoppel, by something, the defendants or their predecessors could take production that would not perpetuate the royalty interest and convert it into production that does perpetuate the royalty interest?
I think, Your Honor, by characterizing this as production that did perpetuate the royalty interest, that's what the operator in effect has done. And by accepting that and not challenging it, and by benefiting from it over many, many years, the defendants simply cannot now come and disavow that and rewrite history. They're stopped to do so. They've waived the right to do so, and they're time barred in their effort to do so. And I can walk through the case law on that and intend to do so in just a few moments.
Okay, but should your clients be able to benefit by that? By that, I mean, I think the reason you have estoppel and waiver and all these things is that you don't want people to lie behind the log. But what recourse would your clients have had if there was no production perpetuated their term royalty interest?
Well, Your Honor, if there was no production and no conduct by the other parties to perpetuate the interest, then we wouldn't be here. But the fact is that this well did produce until 2014. The production was reported as production from the Schnitz-Rydell well for the benefit of all the unit holders, including the Frells, and monies flowed as a result of that characterization. And it did, in fact, treat production out of this very well from beneath these three tracts as unit production.
Okay, go ahead, sir.
Okay, thank you, Your Honor. And finally, the effect of reclassification of that well to gas in 1972. We'll talk about that disputed legal issue as well. So getting back to where I was, the production from the Schnitz-Rydell well was unit production, treated that way by all parties, reported that way to the Railroad Commission. None of that's disputed. Royalties were paid to the unit participants from the Rydells and the Frells and the Schnitzes, not just the Schnitzes. And that includes the defendants and their predecessors, as well as the plaintiffs and their predecessors for many years. Paid to the royalty owners, including our clients and their predecessors. So our position is the defendants are now barred from disavowing that production. So there's been a lot of talk by Mr. Waymeyer about these allegations of impropriety, about Carbon doing something that they weren't authorized to do in 1992 and reporting production differently from the formation from which it came. And I want to be clear that these allegations that are being made are against the operator, Carbon. These are not allegations in any way, shape, or form that are being made by the plaintiffs or by any of the plaintiffs' predecessors. There's no argument that the plaintiffs were involved in any of that in any way, or that they were actually aware of it or supported it. This is something that is being alleged about Carbon and their conduct in 1992. And sometimes that can get conflated that there was fraud. There was no fraud by anybody on the plaintiff side of this case. We were just receiving royalties as the defendants and their predecessors were, believing that it came from the Edwards formation back in 1992, because it wasn't reported any other way. It was clear something changed in 1992 because the payment being made no longer on primarily gas production. All of a sudden in 1992, there was payment on production of large quantities of oil. So it's clear to everybody something happened in 1992, but nobody was told about that. And so plaintiffs are not in any way involved in these allegations that the defendants have raised. I heard Mr. Waymeyer say that somehow the plaintiffs have stepped into Carbon's shoes. I didn't really understand that. There's no legal theory under which the plaintiffs are stepping into the shoes of the operator for purposes of this production or otherwise. We are simply term royalty interest owners, NPRI owners, and our role is we own royalties that we bought in the 1960s. And if they perpetuate by production, we're entitled to share in that. Going forward, we're entitled to share in that if it's been perpetuated by production. But we don't have any say or any role in recompleting a well or in any of the filings of the operator with the Railroad Commission. So I think that's just a misstatement that we stepped into the operator's shoes. What is clear is that from 1992 and before, there was production from this well, and the production from 1992 to 2014, that production came from the Austin Chalk Formation, and royalties were paid and received by all parties in this case and their predecessors on that production. And when Carbon did report the recompletion to the Chalk, their intent to do so in 2009, Mr. Waymeyer showed you that they reported their intent to do that. And he pointed out that that had already happened 17 years earlier. What's interesting is when they did report that, nobody disavowed that production. Nobody said, we don't want to share in that. They signed up a new lease and made sure that they were going to get paid royalties. And that's exactly what would have happened if anybody had tried to cure this by timely complaining of it in 1982 or at any time after the Chalk unit was formed. Any party could have said, wait a minute, that's not right. The Frells lease says that it's only for the Edwards. They would have said, well, we want to produce from the Austin Chalk. Do you want to share in the royalties? The pooled unit's still there. We're still going to pay to the Schnitzes and the Reidels. Do you want in or not? And of course they would have wanted in. There would have been no reason for them not to. And that's exactly what ended up happening in 2009 and 2010 is new papers got signed up that allowed them to participate forward. But somehow in the midst of all that, they've managed to exclude the plaintiffs who are the NPRI owners from any of that production, which we do contend would have been a breach of the duty of utmost good faith and fair dealing. So let's talk about that 1982 pooled unit. What does it say? It was recorded by Shell in 1982. And it makes clear that this unit was pooled as to the Austin Chalk Formation. And where's that located? Well, it's located at 10,800 feet below the surface. It's clear a formation refers to something more than simply a single data point below the surface. And this is simply a shorthand for referring to the approximate area of the formation, the floor of the formation, the approximate depth of the formation. But what it's pooled for is clear. It's pooled as to the Austin Chalk Formation, which is a known subsurface formation that geologists can study and disagree about exactly what foot the top is or what depth the bottom is. This attempted to stab it at approximately 10,800 feet. And we submit that that's the floor of the formation, and the formation itself is what has been pooled in the 1982 designation. Now, this language is important. It talks about that the lessees, that's Shell, execute this instrument as a designation of pooled unit pursuant to the powers to pool contained in leases, as said leases have been amended, supplemented, and or ratified. So it's possible based on the four corners of this document, and this was signed under penalties of perjury by Shell, that there were amendments or supplements or ratifications of the 1956 Frells lease and this pooling that were not filed in the real property records. This document was recorded in the real property records. And then it says, we hereby declare that all of said leases as so amended, supplemented, and or ratified, and all royalties, overriding royalties, production payments, and other interests thereunder are hereby pooled and combined to establish an 80-acre pooled unit, same size unit as the prior 1964 unit, as shown on the attached Exhibit A and as described in Exhibit B hereof, pooled as to the Austin Chalk Formation. So the defendants say this violates the Frells lease, and they point to paragraph 13E. This is the 1956 Frells lease. And it says that a unit can be established, modified, or dissolved in no event later than 20 years after the date hereof. But what they don't talk about is the provision that none of the defendants or their predecessors have ever complied with even today. And that is paragraph 11 of the Frells lease, which requires that in the event the lessor, that's the defendants and their predecessors, in the event the lessor considers that lessee has not complied with its obligations hereunder, both express and implied, lessor shall notify the lessee in writing, setting out specifically in what respects lessee has breached this contract. Lessee shall then have 60 days after receipt of said notice within which to meet or commence to meet all or any part of the breaches alleged by lessor. So this is an obligation, an affirmative obligation on the part of the lessor, mineral interest owners, the holders of the executive rights, the defendants and their predecessors. It's an affirmative contractual duty that they owed to give notice in writing if they believe there's been any non-compliance with the terms of this lease. And that's what they're alleging in this lawsuit, is that there was non-compliance with this lease by pooling in the Austin Chalk in 1982. But they didn't comply with paragraph 11 of the lease, and they didn't bring a claim. And so that's why we allege that they're barred from doing so now, many decades after the fact. Let's look at what the Railroad Commission records show, because that also shows that this pooling had occurred. This is the certificate of pooling authority that was filed by Shell in the same period, the early part of 1982, which shows that the acreage claim for the purpose of establishing a pooled drilling or proration unit, and we'll get to the property description, it's this Austin Chalk designation. And what the Shell records showed, filed in the Railroad Commission records, is that the parties now owning those mineral interests, the parties have pooled those interests in such manner that all of such pooled units shall be considered as one base tract. That's what Shell told the Railroad Commission in 1982, is that the parties had pooled their interests. And this was signed under penalty of perjury, shows the 1.85 acre tract of the Frells tract, as well as the Rydell and Schnitz leases. And this is the certificate at the end. It says, I declare under penalties described in section 91.143 of the Texas Natural Resources Code that I'm authorized to make this report, that this report was prepared by me or under my supervision and direction, and that the data and all facts stated therein are true, correct, and complete to the best of my knowledge. This was April of 1982, almost 40 years ago, that Shell certified in the Railroad Commission records that the parties had pooled their interests for this chalk unit. And Your Honor, that's admissible evidence in this case to show that the owners agreed to pool their interests in 1982. Shell's statement in a publicly filed document and under penalty of perjury shows that the owners pooled their interests. That's admissible for the truth of the matter asserted therein under multiple exceptions to the hearsay rule. Under 803.16 of the evidence rules, this falls under the ancient documents rule. It's a document that's more than 20 years old. It also is a statement in public documents affecting real property, and it's records of documents affecting an interest in real property. So it would fall within 803.16 as well as 803.15 and 803.14, that statement in the public records from nearly 40 years ago is admissible for the truth of the statements made therein that the owners pooled their interests in 1982. There's also a permit application in 1982 by Shell. This was a permit application not for a single data point, not for 10,800 feet below the surface, but for the Austin Chalk Formation, 10,495 to 10,585. That's in the Chalk Formation, and it's going to be an oil well. This is a contemporaneous record by Shell showing their intent when they created the pooled unit designation, that it was, as the document states, for the Chalk Formation and not simply for a single location beneath the surface. And that permit to recomplete in the Austin Chalk was granted in May of 1982. It was a plug back operation for this Schnitz-Rydell unit well to the Austin Chalk Formation. And again, nobody complained when a permit was sought. Nobody complained when a permit was granted. Nobody complained when the unit was formed. Nobody complained when Shell put in the public record that the owners themselves had pooled their interests. Now, here's deposition testimony. This is attached as Exhibit 4. And this is Mr. Bob Brandt, who's the president of Carbon Oil Company, which was the operator from 1983 until the well was plugged in 2018. And I asked Mr. Brandt, did anyone from Shell ever tell you that they'd received a complaint about this designation of pooled unit in the Austin Chalk Formation? And he said no. No one from the Frells family ever complained to you about the formation of that unit? Mr. Brandt said no. Did any assignees of the Frells and the Frells tract ever complain to you about
Mr. Weimeyer, I believe, has an objection.
Your Honor, I just don't want to be construed as waiving any objections. We filed written objections to all of these. As you see, form was preserved at the time. And so they detail specifically things in response here, like hearsay. You know, did anyone from Shell ever tell you that they had received a complaint? That's hearsay. With respect, there's no showing of witness foundation. There's no predicate. All of this is detailed, and I'm happy to take these up at the end. I just don't want to be construed as this being evidence in the record.
All right, Mr. Kildane,
I'm sorry?
Okay, you're happy to agree that the defendants aren't any objections they've already filed, not new ones as far as evidentiary?
Your Honor, we saw that some objections got filed less than 2 hours before this hearing was supposed to start this morning. We have not read those in any detail in preparation for this hearing, but I heard Mr. Weimeyer say he wanted those argued, if at all, toward the end of this hearing. And by then, perhaps we can take a look at what he filed this morning and be able to meaningfully respond, but we have not studied those objections.
All right, I just want to make sure that everybody's on the same page, that the defendants don't need to go and repeat any evidentiary objections they've already filed while you're speaking.
That's fine with me, Your Honor. We've not, as I noted, we've not studied those objections at this time. So
right, thank you.
Thank you, Your Honor.
Go ahead.
Okay, so did any assignees of the Frells and the Frells tract ever complain to you about the formation of this pooled unit? Answer no. And again, this is going to notice of an alleged violation of the lease, and there was none given. So did Carbon pay those royalties to the various participants in the Schnitz-Rydell unit starting in 1992? Answer, yes. Did you pay royalties to the Rydell tract owners? Yes. Did you pay royalties to the Schnitz royalty owners? Yes. And did you pay royalties to the Frells? Answer, yes. Did you also pay royalties to the term royalty interest owners? That's our clients. Answer, yes. And those royalties were paid out of that production in the Austin Chalk. Answer, yes. The production that the real property records reflected as of 1982 was pooled as ratified, as now shown of record in Karnes County, correct? And the answer was, I guess so. Question, okay, did anyone ever come to you and say, that's not true, I never ratified the use of my tract for a pooled unit in the Austin Chalk? Answer, no, no one ever said that. And then finally, this is on page 361. Mr. Brandt, I'll keep this real short. Let's take a look back at Exhibit 61. And Your Honor, Exhibit 61 in the deposition record is the 1982 pooled unit designation filed by Shell. Let's take a look back at Exhibit 61, the pooled unit for the Chalk Formation. Are you aware of any challenge that was ever made to the validity of that designation of pooled unit? Answer, no. After 1992, was there production from the Austin Chalk Formation out of the Schnitz-Rydell well? Answer, yes. And royalties were paid on that production. Answer, yes. Did anyone ever complain about receiving those royalties? No. Did anyone ever complain about the production that generated those royalties? Answer, no. So EOG and Carbon, moving on to the next item, this is the document I referred to at the beginning where EOG and Carbon made an agreement that included the agreement that production from the Schnitz-Rydell well perpetuated interests that are similar to the interests that the plaintiffs are claiming here. This is an October 2013 agreement between Carbon and EOG. And in paragraph 7 of this agreement signed by Carbon and EOG, this attached as plaintiff's exhibit 10 is some deposition testimony from Mr. Brandt. And then behind that plaintiff's exhibit 10, this is deposition exhibit 28. What EOG agreed with Carbon in 2013 was the parties here to recognize that continued operations on or production from the wellbore, that's defined to be the Schnitz-Riedel unit well, operations on or production from the wellbore have been perpetuating and will continue to perpetuate the leases beyond the expiration of the primary term as provided therein. Being so, Carbon et al. Agree to notify EOG within 7 days if for any reason production from the well ceases, unless production is restored within that 7-day period. EOG wanted to be sure that this production continued to perpetuate interests so that their new production starting in March 2014 would be an ongoing perpetuation of leases signed by the Riedels and the Schnitzes, as well as the recent lease signed by the Frels. In addition, Carbon et al. Agreed to provide EOG monthly production reports for the wellbore. The production report shall be provided within 7 days from the end of the previous reporting month. The obligation to notify EOG for any cessation of production and to provide monthly production reports shall terminate on the date on which EOG commences operation for the drilling of the well on the leases or lands pooled therewith. And that's exactly what, Your Honor, that's exactly what Mr. Brandt testified is what happened, is that EOG required Carbon to continue producing from the Schnitz-Riedel well until they established production from their new wells in March of 2014. And at that time, they gave notice to Carbon that they could and should stop producing the Schnitz-Riedel well. And if you look at paragraph 6 of this agreement, deposition exhibit 28 attached to plaintiff's exhibit 10, it says Carbon agrees within 60 days after written notice from EOG to plug the wellbore in accordance with the rules and regulations of the Railroad Commission. So they did continue operating the well at EOG's direction until EOG established production. Then EOG said you can stop producing, and that's why they stopped producing the Schnitz-Riedel well, and then eventually the well got plugged. So undisputed facts, continued production as unit production, continued payments to the defendants and their predecessors, no action to dispute or protest that production. And we contend the legal effect is that the defendants are now time barred to complain of any alleged breach of the Frels lease, that having accepted the benefits of that payment of royalties under unit production, defendants and their predecessors are now stopped from denying this was unit production under the doctrine of quasi-estoppel. And the defendants have waived any objection to that production being treated as unit production. And further, that the defendants have ratified this as unit production. So I want to go through these one by one. I don't want to belabor this too long, but let's talk about limitations first. Starting with the Hay case, this is cited in our briefing. The Hay case in 1999, this was a claim by Hay for breach of a lease. For doing what? For improperly pooling without lease authority. That was the claim in Hay. And Shell defended that claim by saying that the claim is barred by limitations. And the court agreed. The court said that that claim was barred by limitations and that the act that caused the legal injury occurred at the time when the pooled unit was designated and formed. That's the triggering event that triggers the 4-year period for limitations for a complaint about breach of the lease. And there's another case I want to talk about in just a moment from Austin, but the Hay court said because more than 4 years had passed since the formation of the unit, that the claim for breach of the lease was time barred. The Austin case in the year 2000, the Browning Oil Company versus Lucky case, is the opposite of Hay. It's the inverse, flip side of Hay. In this case, there was a similar claim for breach of a pooling clause, and the operator challenged that claim as untimely. But here, the claim was filed within 4 years of the formation of the pooled unit. And having filed suit within 4 years of the formation of the pooled unit, the claim was found not to be time barred. So these two cases are consistent with each other. They teach us important lessons that apply here, which is that a challenge for improper pooling, like what the defendants are claiming here, is a claim against the lessee for breach of lease. and the claim accrues when the improper pooling occurs. And if it's not filed within 4 years of the date when the pooled unit designation is recorded, then the claim is time barred. And we say that claim is time barred, and it can't be brought up now as a defensive measure in our lawsuit to dispute decades of production that was treated as pooled unit production and accepted by the defendants as unit production. And these principles apply especially where you've got an express provision in a lease requiring the lessor to give written notice of any complaint for an alleged breach of the lease, with the lessee having an opportunity to cure for 60 days after receiving that notice. You know, Carbon no longer cares about this issue. They've plugged and abandoned that well and moved on. So at this time, there's nothing for them to cure. But certainly in the 1980s, when this pooled unit was formed, it would have been very easy for Carbon to send out a landman to sign up new leases and ask people if they wanted to receive money from production that was going to occur from the Austin Chalk, from a unit that existed that included their land, or do you not want to be paid money? And there's no question they would have done exactly what they did in 2009, 2010, which is they agreed, and they would have agreed at that time back in the 1980s. Carbon was deprived of that opportunity to cure. And because of that, we believe the defendants have waived and are stopped and are barred by limitations to challenge it now. The defendants have alleged the discovery rule. Well, the discovery.
But again, how are your clients beneficiaries of any right to cure Carbon would have?
Your Honor, what we're beneficiaries of is the ongoing production that went forward for decades that was treated as unit production, and the defendants accepted and received royalties as unit production. So we benefit from that because of these doctrines of quasi-estoppel and waiver and limitations, because the remedy for the defendants is to go after Carbon, and they needed to do that in a timely way. They didn't, and instead they made a decision to go forward and accept royalties as unit production. Having done so, they cannot now go and rewrite 4 decades of history and contend self-servingly that this shouldn't have been treated as unit production all those years when they received the money.
Okay, but if the defendants had done that successfully at the time the attempted pooling designation occurred in 82, then your clients would have been deprived of a decade and a half, and in some cases, 2 decades or 2.5 decades of receiving royalty payments.
Well, Your Honor, again, I think that duty that the executive rights holder owes to the non-executive holder would kick in at that point. Do you even have the right at that time to take action that would cut off the NPRI owners at the knees by just treating it as having terminated and not going forward to accept royalties going forward? There are duties that they would owe at that time that are implicated here. And we say and argue in our briefing that they were not at liberty to decline to participate in that because it would have impaired the NPRI owners under the duty of utmost good faith and fair dealing. But that's not what happened here. What they did is they chose to participate in the unit going forward and treat the production as pooled unit production.
Go ahead, sir.
Thank you, Your Honor. So the discovery rule doesn't apply. This comes back to the Hecky case we discussed a few moments ago from the Texas Supreme Court, 1998. This was that suit for breach of lease for improper pooling.
I'm sorry, I've got to take a call again.
Okay, absolutely.
All right, I'm sorry. Go ahead, sir.
Thank you, Your Honor. I mentioned that they would have needed to sue Carbon. That would have been 1983 and thereafter, but in 1982, it would have been Shell, which was the operator at that time. So I misspoke on that. I apologize. But picking back up where we were on the discovery rule does not apply in this instance. The Hecky versus Neal case in 1998 was a suit by royalty owners for breach of lease. The claim was based upon an allegation that the operator breached its obligation to notify the landowners, the royalty owners, that there had been an injury to the common reservoir by an adjoining operator. There was an obligation in the lease that required that notice. And the claim in this lawsuit was that the lessee had breached the lease because it failed to timely notify the royalty owners of that injury to the reservoir. The court held that this claim was time barred. It was filed too late. You made a claim about breach of lease and you did it too late. And importantly, they noted that the discovery rule does not apply because the underlying facts showing the breach were not, quote unquote, inherently undiscoverable. In order for the discovery rule to apply, there needs to be facts you are unaware of that were not inherently discoverable. And here the court said those facts were not inherently undiscoverable. They could have been discovered. And they noted that the filings and other materials publicly of record and publicly available from the Railroad Commission were a ready source of information. And because those facts and those details showing this alleged wrongdoing could have been found by the royalty owners in the Railroad Commission records, that they waited too long to make a claim against the lessee, the operator. Similarly, another case, we've heard a lot today about Wagner and Brown versus Shepard. We're going to hear more about Wagner and Brown versus Shepard. This is a different case. This is a 2001 case, Wagner and Brown versus Horwood, which relates to a similar issue, a suit by royalty owners for breach of a lease. The claim in that case was based on alleged underpayment of past royalties. And the court held that the claim was, again, time barred as to those claims for royalties accruing more than 4 years prior to the date the lawsuit was filed, that the claim was time barred and the discovery rule did not apply because the underlying facts, again, were not inherently undiscoverable. And the court actually went further than the Hecky court. The Wagner Brown versus Horwood court said that although the facts revealing the injury were not available in public records, the claimants had other sources of information, including the statutory right to request and receive information from the lessee operator. So just that fact, just the fact that they could have made a request of the lessee operator to gain information and they failed to timely do so, was enough to say that this claim against the lessee operator was time barred. And the third in this trilogy of cases dealing with the discovery rule not applying is BP versus Marshall, Texas Supreme Court 2011. Again, a suit by royalty owners against the lessee operator for breach of the lease. In this case, the claim was based on the operator's breach of its obligation to continue good faith efforts to develop the lease, an improper development claim. And the court held, as the Hecky and the Wagner Brown versus Horwood courts held, that this claim also is time barred and the discovery rule did not apply because the underlying facts were not inherently undiscoverable. And here the court again looked to publicly recorded documents, information disclosing the operator's actions. That information was available from the Railroad Commission files. So the discovery rule doesn't help the defendants here. If they wanted to complain about this 1982 pooled unit, they needed to do it back in the 1980s, and they did not. And that's the lesson from Hecky, Horwood, and Marshall, is that the claim is time barred if it's based upon conduct dating more than 4 years back. And I guess getting back to your Honor's question, if they're time barred to complain to the lessee operator, then clearly they're time barred to complain to others, because the claim for breach of lease is a claim against the lessee operator. And having allowed that claim to expire by the passage of the statute of limitations, they are now deemed to have accepted the ongoing operations that are consistent with what was recorded in 1982. And we'll get to that in a moment. So the discovery rule doesn't toll limitations where those underlying facts weren't inherently undiscoverable. Documents in the public records, including Railroad Commission documents, are not inherently undiscoverable. Those are readily available to the defendants. And for that reason, the discovery rule doesn't help them, and they're barred by limitations. So let's move on to when the defendants acquired. The defendants in this case, all of them acquired the interest that they own after 1982. And therefore, they acquired their interests in the Frells Tract subject to the 1982 pooled unit designation. And we know that from also the Hecky case that we just talked about, the suit for breach of the lease about the injury to the common reservoir. The information, as the court held, showing that injury was available in the public records, and the court held that the purchasers had constructive notice of all matters reflected in the public records. Same is true here. These purchasers, these assignees, these subsequent owners of the mineral interests in the Frells took those interests subject to the 1982 pooled unit designation. They were on constructive notice of that as it affected the tract that they took parts of or pieces of whenever they acquired their various interests. So let's move on to waiver. That's limitations. Let's move on to waiver. In the Tenneco case in 1996, the Texas Supreme Court noted that waiver is the intentional relinquishment of a known right or intentional conduct that just is inconsistent with claiming that right. And that's what we have here. Evidence of silence or inaction for an extended period of time can be sufficient to establish intention to waive a known right. And again, that's what we have here. Silence or inaction for more than 35 years as to this 1982 pooled unit that was filed of record by Shell. The Tenneco court held in 1996 that the failure to complain about breach of a contractual provision for over 3 years established intentional waiver. And here we have failure to complain about any alleged breach of a contractual provision in the Frells lease for over 30 years after the 1982 pooled unit was formed. The undisputed facts in our case show waiver. There were certainly constructive knowledge, constructive awareness of the lease terms and the 1982 pooled unit as soon as those documents were recorded in the real property records of Karnes County, and no action was taken for over 35 years. There was no effort to comply with paragraph 11 of the Frells lease to give notice and an opportunity to cure. No notice, no opportunity to cure. So that's waiver, Your Honor. And we believe that as a matter of law, the defendants have waived their right to complain about the production from the Schnitz-Rydell unit well being treated as unit production. So let's move on to quasi-estoppel. Quasi-estoppel prevents a party from accepting the benefits of a transaction on the one hand, and then subsequently taking an inconsistent position to avoid corresponding obligations or effects. And that's exactly what we have here, Your Honor, is decades of accepting benefits as unit production, and now coming to the court trying to take a completely inconsistent position that no, that was not unit production. That should now be retroactively treated as lease production only for the Schnitzes. Nobody's given their money back to the operators or to the other tract owners, but they're taking an inconsistent position now that they're stopped from doing so under the doctrine of quasi-estoppel. This statement of the law, Your Honor, comes from the Lopez case in 2000, Texas Supreme Court. And then quasi-estoppel does not require proof of a misrepresentation of existing facts or detrimental reliance. That comes from the Vessels case in 1992. So what do we have here? Well, we have facts showing that that's exactly what the defendants did. And I want to talk about the Cambridge case in 2009 out of Amarillo. This was a challenge by mineral owners to a unit designation. You shouldn't have been able to pool that. They're challenging the pooled unit designation, and they made a claim seeking termination of leases. And in the Cambridge case, there was a well called the Prater number 1 well that was completed at certain depths in section 39, but sections 39 and 33 were then pooled at different depths. So similar to what's being alleged here, that there was a unit designation for one depth, and in fact, they did production from that well at a different depth. It's slightly different here, but the Prater number 1 well was completed at one depth. The pooled unit designation said that it's pooled as to a separate depth. And based on that discrepancy, the mineral owners in Section 33 sought to terminate the Section 33 leases, and they challenged the Prater unit designation, saying, wait a minute, different depths, just like here. Wait a minute, that's from the Austin Chalk, not from the Edwards. They complained about the discrepancy between the depths of the pooled unit designation versus where the well was completed. But what the court held is directly applicable here, which is that because those mineral interest owners had accepted royalties from that well under its designation, that the principles of quasi-estoppel would bar any subsequent challenge to the validity of the unit. Your Honor, that's exactly what we have here. The facts of Cambridge are exactly on point, and the defendants have done exactly what the complainants did in the Cambridge case. They waited 30 some odd years to complain about the completion having a discrepancy from the pooled unit designation. And the court held correctly that quasi-estoppel will bar you from making that challenge later after having accepted those benefits from the pooled unit. And the defendants here accepted benefits from the pooled unit, the Schnitz-Rydell unit, over many years, including continuing into 2014. And they are now barred by quasi-estoppel to challenge the validity of the 1982 pooled unit designation.
And do you think it makes any difference? What was it, the 1992, whenever the well was completed to another depth?
Your Honor, the completion that happened in 1992 was to the Austin Chalk formation, and there's summary judgment evidence showing that. The defendants got all excited because that's different from what the pooled unit designation said back in the 50s, that it said it can be, 1960s, the pooled unit designation said the Edwards only. And so the defendant said, this doesn't count, even though we pocketed the money, this doesn't count because it's for the Austin Chalk. I think it'd be a very different case if there weren't a pooled unit designation that specifically addressed production from the Austin Chalk formation. But here, that's what we have. The operator pooled a unit. In fact, the operator said that the owners of the minerals pooled their interests for the Austin Chalk formation. And that's where this production came from. To your specific question, would it have made a difference without that 1982? I think, yes, it would have made a difference. I'm not sure it would have been a case dispositive difference because the Cambridge case would still be on point, even in the absence of that 1982 pooled unit designation, that the complaint about a well production depth differing from a pooled unit designation, if you accept and receive the royalties for many, many years, you can't now take an inconsistent position and say that that shouldn't be treated retroactively as unit production. So I think the result would be the same, but it's a lot clearer case since we have that 1982 pooled unit designation.
Okay. And I'm sorry, just to let the attorneys know, I think you'd announced about 3 hours. I need to take off at 4:50 sharp.
Okay. Thank you, Your Honor. And I'm about to.
With respect to the defendant group, we announced the three, everybody was in agreement. We stayed true to less than our half of the three. And I've got a lot of things I'd like to say in reply to this, and I can do that in 10 minutes.
Okay, okay. Well, we came back at 3 o'clock, I think. So was that correct?
I think so, Your Honor. 3 o'clock was when we started. So it's been an hour.
Again, we've got another 40 minutes. I just wanted to not drop that as a surprise. I just got a text back. I've got to pick up a son.
Thank you, Your Honor. And we'll wrap up whenever the court needs to and pick up again tomorrow. I just do want to point out that we're not only responding to 4 motions that the defendants filed, we're also advancing our argument on our own motions for summary judgment. So, 3 hours for the defendant's motion, but we need our own time for our motions, which we announced for 3 hours as well. But I'm about to wrap up on this portion of it, and Ms. Keeney will need to address the issues relating to the Wagner-Brown and the release of the Frells lease. But we respectfully urge that the court must deny the defendant's motions on these points because of the doctrines of waiver, quasi-estoppel, and limitations and ratification. Defendants have failed to show that production from the Schnitz-Rydell unit well ceased to be unit production after 1992. And in fact, they're stopped from making that claim, and they're barred from making that claim. The facts and the history conclusively show that all parties treated this as unit production. Production from the Chalk formation was expressly authorized by a pooled unit designation in 1982. Defendants took no action to timely challenge that, and they did not comply with the lease requirements for notice and opportunity to cure. On the other hand, the plaintiffs have established their entitlement to summary judgment as a matter of law on the issues of limitations, waiver, and quasi-estoppel. So this is just a very quick point. This gets to the reclassification, Your Honor. In 1972, this is the Sierra Bank of Cyrus Minerals motion. They claimed that in 1972, there was recompletion of the Schnitz-Riedel unit to the gas layer of the Edwards. And at that time, it became reclassified as a gas well. And they point to the original pooled unit designation in the 60s to say that it's now classified as an oil well. I just want to show we've got summary judgment evidence. Exhibit 5B attached to plaintiffs' motions and responses shows that even as late as 1983, the plaintiffs and their predecessors were still continuing to receive royalties. So the participants in that pooled unit did not adopt the understanding that Mr. Waymeyer and the other defendants want the court to adopt. The operator and the parties involved treated the well as being classified as an oil well at the beginning and did not treat reclassification as somehow changing how it was treated as unit production. So the reclassification in 1972, first of all, that's irrelevant to our position because the Frells well number 1 produced from 1972 to 1992. So we don't even need the Schnitz-Riedel unit well during that 20-year period of reclassification as a gas well. The language of the designation itself leaves open the argument, and we believe the party's course of dealing conclusively shows this was the intention, that if it's classified as an oil well when it's drilled, it's always an oil well for purposes of the lease and for purposes of the pooled unit designation. That's how the parties treated it. The language from that pooled unit designation back in the 60s, all production, both liquid and gaseous, produced from a well, which is classified as an oil well by the Railroad Commission. Well, this well was classified as an oil well when it was drilled. And the course of dealing of all parties showed the intent not to change the treatment of that well and the production from that well upon a reclassification as a gas well. The Schnitz-Riedel well meets all the requirements of having been drilled as an oil well. And again, we go back to the same doctrines we've discussed in detail in connection with the other issue of accepting the benefits for decades with notice of the reclassification in the public records. There's been waiver, quasi-estoppel, and limitations. And I've talked about the Tenneco case. It's the same principles we already discussed. I know the court's got limited time. I'll point out that
take your time. I mean,
okay.
4:50 is
So
35 minutes still.
Okay.
No, almost.
Well, I want to be sure Ms. Keeney gets an opportunity to address the Frells lease release from 1997 on motion for summary judgment number 1, and also as part of our summary judgment motion number 2, which is the second block of matters that are set before the court, which we announced for 3 hours for. So there was a failure to complain regarding breach of contractual provision for over 3 years. That established waiver. Here we have a failure for nearly 50 years on the reclassification, even though the public records at the Railroad Commission show reclassification. The Trellex case in 2016 makes clear that although waiver refers to known rights, proof of a party's actual understanding of legal consequences is not required. Instead, it's sufficient if the party simply has reason to know of the essential facts, and that relies on the restatement of contracts. So on quasi-estoppel, the same principles will apply, looking at the same cases we've already discussed for this reclassification issue. I won't go through that in detail again on quasi-estoppel. We believe the defendants are stopped and have waived any complaint about their 1972 reclassification. They accepted the royalties for decades. Now they're trying to take a subsequent inconsistent action of arguing that that somehow was not unit production. They could have complained about it in 1972. They were on constructive notice. They did not. Instead, they chose not to complain, and they chose to accept and receive royalties. Having done so, they're now barred to take a separate and opposite position. So we asked for the motion to be denied, the defendant's motion to be denied, and for ours to be granted on this reclassification issue. That's part of our second motion for summary judgment. We believe the facts and history conclusively show that there's been a waiver and that there's been an estoppel and bar by limitations for that production, as well as a ratification. All that production was treated as unit production, and the defendant accepted those royalties. So we asked for the plaintiff's motion for summary judgment on the reclassification to be granted as a matter of law. And then I will address this one point about the specific depth level being the only area that could be produced from, which practically is an absurd position, a nonsensical position. Formations don't exist at an exact millimeter of depth. They exist as a formation, and the pooled unit designation in 1982 used the word formation as the formation for which it was pooled, the Austin Chalk. There's the language from the 1982 pooled unit designation, Exhibit 1H, attached to plaintiff's motion, that these lands, including a portion of the Frells Tract, were pooled as to the Austin Chalk formation. And we believe that the defendant's argument on this, that it was a single depth only at 10,800 only, that's contrary to the plain meaning, uses the word formation. I've got Oxford Dictionary talks about a formation being an assemblage of rocks or series of strata having some common characteristics. Merriam-Webster defines a formation as a sedimentary bed or consecutive series of beds sufficiently homogeneous or distinctive to be a unit. There's no argument that a pooling for a formation could somehow be deemed to be from 10,800 feet only and not a few feet above that within the same formation. It's also contrary to common sense, and we believe this argument's unreasonable as a matter of law. And importantly, maybe most importantly, it's contrary to Shell's own contemporaneous interpretation, as we showed in the permit application that they filed, where just in the same month as they pooled this unit, they showed that their intent was to drill at 10,495 to 10,585. So it's clear that the 10,800 was intended to be an approximation or a floor of the formation, and that any production within the Austin Chalk formation would be within that pooled unit. So we believe the defendant's motion on this issue must also be denied, that the 1982 pooled unit designation pooled lands for the Austin Chalk formation. There's no reasonable interpretation that it limits pooling to a single point, and that the only reasonable interpretation is that the designation is pooled for the formation itself as stated in the pooled unit designation, and the depth is either an approximation or the estimated location of the floor. And at a minimum, the plaintiffs have raised a fact issue on this issue that would preclude the granting of summary judgment in favor of the defendants. So conclusion, we've established conclusive evidence to prove waiver as a matter of law. We've introduced conclusive evidence to show quasi-estoppel as a matter of law, and also limitations, and therefore the plaintiff's motion should be granted. Defendants are barred from challenging that 1982 pooled unit designation for the Austin Chalk, having accepted and received royalties for so many years. And EOG signed a written agreement contending that production had perpetuate the interests of the Rydell lease and the Frells lease. And defendants are barred from challenging the post-1972 production as unit production. And again, at a very minimum, we've raised a fact issue that would preclude summary judgment being granted in favor of the defendants. So we respectfully request that DDR Gaddy's 3rd, 5th, and 7th motions be denied. We respectfully request that Sierra's motion for summary judgment be denied, and that plaintiff's first motion for summary judgment, which covers overlapping issues therein, be granted. And I'll defer to Ms. Cnty to address the plaintiff's motion for summary judgment number 1 and DDR Gaddy's motion for summary judgment number 1. And then we'll table the issues relating to whether the term royalty interests allow for production to count from lands pooled with the Frells Tract. Mr. McFarland will address that after the defendants argue their 2nd and 4th motions. And I thank the court for your time.
All right, go ahead, ma'am.
Okay, thank you. And I will try to cut this down. We weren't sure which order this was going to go in. Marianne, can you get can we put up a screen share? Ms. Nitch was going to put that up for me if she would.
Yes, I'm pulling it up right now.
Thank you. Okay, just to be clear, this issue addresses, this argument addresses plaintiff's response to defendant's MSJ number 1. And that's actually the DDR Gaddy
MSJ number 1 that most of the defendants, if not all of them, have joined in. And then EOG's MSJ. And then it also deals with our motion for summary judgment number 2 on this issue, which we cover at pages 12 through 15 of our motion number 2.
I've got those pulled up. Go ahead.
Okay.
Your Honor, may I be heard on a brief point of procedure?
Yes, sir.
Mr. Kilday asked at the last hearing that we agree on an order of the presentations, and we conferenced and caucused with him on that. We reached agreement, and we presented the court with an agreed letter on that. And what that provided for was for motions 1, 3, 5, and 7 to all be presented and concluded. And at the end of that conclusion, they could present their motions 1 and 2. And now what we have is apparently he's said they've, so I get, I don't whine about matters of procedure, but here, it was specifically his request that we handle this in this fashion and that we handle it on the 3-hour announcement. And now they're arguing additional motions after we conferred and gave you a letter per the court's request.
All right, I understood him to say he wanted 3 hours for his motion on the merits.
And I would just like, again, the first group of motions was 1, 3, 5, and 7. And I would just like an opportunity to conclude those before the record on that is muddied with whatever he wants to present. And that's consistent with the letter we submitted to the court as agreed.
Okay.
Your Honor, the point of having them heard together was because they're the same issues. So I believe I've concluded our presentation on our motion as to the 1982 pooled unit, as well as the production from the Austin Chalk. The point is that these are overlapping and interrelated issues, and the order is set out that they go first and then we go, but we need to be able to present our argument as to the release of the Frells lease as well, which is their motion number 1.
All right, go ahead, ma'am. I'll just proceed from where we are.
Okay, and we can just kind of run through these PowerPoints. The next screen, please. It's niche. I seem to have lost my assistance on the PowerPoint. There we go. Okay. And we can, let's go ahead and skip to the, let's go ahead and just skip to the 1997 release, because what we have here is an agreement. Here, basically the defendants contend that when Carbon agreed to release the Frells lease in 1997, that extinguished all of the term royalty owner's interest in production from the Schnitz-Riedel unit. We disagree, and we think that this is clearly controlled by the Wagner and Brown case. In the 1997 release, and I think that Mr. Weimeyer has actually agreed with us on most of this. The 1997 release was just because of a complaint, not about the production from the Schnitz-Riedel well, but only about production from the Frells well. Carbon executed a release so that, and I believe that Mr. Gaddy agreed to plug the well, so it was essentially a savings. And then the release itself says nothing about either the plaintiff's term royalties being terminated or any termination of participation in the Schnitz-Riedel unit. If we can go to the next screen, please. And you can see that. And I believe, so I won't go into a lot of time on this, but I believe Mr. Weimeyer conceded that the release, the 1997 release, says absolutely nothing about the Schnitz-Riedel well or about the term royalty owners. Let's go to the next slide, please. And you can see it was simply done to avoid the risk, disruption, and expense of continuing the litigation.
Okay.
And that's really basically the testimony down there from Mr. Brandt was, yes, we caved in because we didn't want to have a lawsuit, because Mr. Gaddy had threatened Carbon with a lawsuit. So that was why the lease was released. And apparently they didn't realize that the lease did not have a Pew clause, and they could have held the lease with simply the production from the Schnitz Riedel, but they weren't aware of that at the time. So we contend that that 1997 release had no impact on Carbon's participation in the unit and on the royalty owners and the mineral interest owners, the defendant's predecessors, having a right to participate in the royalty production from the Schnitz Riedel unit. And I think this all comes down to, was it a pooling of lands or was it a pooling of leases? And I think that Mr. Weimeyer would agree with that. I think Mr. Truss has actually, he and I would agree that this is actually a relatively simple issue. We agree, we just disagree on how the Wagner and Brown versus Shepard case applies. The Wagner and Brown case involved a lessor who his lease had pooled Miss Shepard's land, which was covered by an oil and gas lease, and Wagner and Brown included the Shepard's lease in a pooled unit. The lease terminated while production from the pooled unit continued because Wagner and Brown failed to timely pay Shepard her royalty. That's an unusual provision, but it provided for automatic termination. And so Mrs. Shepard terminated, her lease terminated. And she argued, I'm out of the unit. I don't owe any production cost. I don't owe anything for this unit. And Wagner and Brown said, no, we're still in, your property is still in the unit because you allowed us not only to pool your leases, but your lands. And the trial court agreed with Mrs. Shepard. The Court of Appeals did too, but the Supreme Court reversed in a fairly predictable decision and said the termination of the Shepard lease didn't terminate her participation in the unit. The court said a lease isn't even required for pooling. Mineral owners can join even if no lease exists. They said here, both Shepard's lease and the unit agreement pooled certain premises and lands, not just their leased interest. And although the Shepard's lease expired, the lands themselves obviously did not. So the court said, while termination of the Shepard's lease changed who owned the mineral interests in the unit, it did not cause the unit to terminate because it was a pooling of lands, not just leases. Let's go to the next slide, please. I think it's undisputed that the Frells lease authorized the pooling of lands. I think Mr. Weimeyer actually made a lot of the points we were going to make, which is that there was broad pooling authority in the 1956 Frells lease, and they could pool or unitize all or any part of said land and of this lease as to any minerals or horizons thereunder. So there was clearly authority under the lease to pool the lands. Next slide. There's also another provision in the Frells lease that would limit the ability to terminate a unit. And the unit is comprised of 3 different tracts of land and necessarily includes the Frells road tract. And that's paragraph 13D of the lease. And it says that a unit shall remain in force so long as any lease subject thereto shall remain in force. And it's undisputed that the Schnitz and the Riedel leases did continue after the Frells lease was released in 1997. There is, go to the next slide, please. There's nothing in any of the term royalty deeds that makes the term royalties dependent on continued existence of a lease. It only requires continued production. And Texas law requires express language in a royalty deed of this nature if you want to terminate it when the lease terminates. And that's just simply not in there. And I don't even think that they dispute that either, Your Honor. So where we are is with the 1964 and the 1982 unit designations, which they only focus mainly on the 1964, but I think we need to look at both. And they say those, let's go to the next slide, please. The question is, did these unit designations just pool the leases or did they pool the lands? The 1964 unit designation says they declare that all of said leases as so amended and or ratified and all royalty, overriding royalty, and all other interests thereunder are hereby pooled and combined. Mr. Weimeyer focused on other language that talked about pooling of the lands. And they said, well, that doesn't do it. But this, and I think it does, but this clearly does. It talks about not just pooling the leases, but pooling royalty, overriding royalty, and all other interests. That was clearly a pooling of all of the mineral interests, which are lands, which are interests in land that were pooled. The 1982 unit designation says essentially the same thing. They're not just pooling the leases, they're pooling royalties, overriding royalties, production payments, and all other interests in the lands. And let's go to the next, we're on to the next slide. And that also provides that it's pooling under the respective lands covered by the said leases. I don't know, it doesn't make sense for them to argue that they were only pooling the leases. If they were only pooling the leases, there would have been no reason to add this additional language. They would have said we're pooling the leases. Instead, they said we're pooling all royalty, overriding royalty, and all other interests thereunder insofar as said leases cover and apply to oil in and which may be produced from the Upper Edwards under the respective lands covered by said leases. Clearly, this falls right within the reasoning and the holding in Wagner and Brown versus Shepard. I think their argument is contrary to the plain language of the leases. I was watching them up on the screen and the language is right there, Your Honor, even when they put it up and they just simply ignore it. I think in the DDR Gaddy motion, which is, let's look at the next slide. Let's go to, I think, let's go to the next slide. The DDR Gaddy motion at page 13 suggests that a royalty was simply referring to the royalty under the lease. And he refers, but that's not the case. It is also talking about the term royalties, the term royalty owners, and all other interests. That simply doesn't provide a limitation for that language. And there is no need for that language if all you're doing is pooling the leases. That's all you would need to say. I apologize. I'm actually trying to make this shorter, Your Honor.
Go ahead, go ahead.
Okay. That's right. Let's go back to slide, I believe it's slide. Let's go to slide 25. even if the contract between EOG and Carbon, where EOG essentially committed to taking over these lands and drilling on them with new leases, committed to taking over these lands and drilling on them with new leases. They acknowledged that the Schnitz and Riedel leases had been kept alive by that well. And recall that the Frills lease, while it may have been terminated, it prohibited termination of the unit as long as those other units remained in effect. You can't pull the land out from that unit and still have it be a unit. And they argue, well, they just took that out and it's gone, but it's part of the unit. And if you pull the lands, you can't pull the land from pull the lands from the unit. We also have in our summary judgment evidence, and I'm not going to go through all the slides, that's what I just had Ms. Nitch pass by, is that there were payments, and I think that were made out of this unit for decades. Everyone treated this as a validly pooled unit that would not be terminated by the 1997 termination of the lease. And that continued for approximately a decade, at least until 2008. Carbon continued to pay both the plaintiffs and the defendants' predecessors for production from this unit, recognizing that it did not terminate this particular unit, and it didn't terminate the rights of the parties. Let's go to slide 26. I'm not sure where you are. Yeah. All right, slide 26. EOG's arguments are similar to DDR Gaddy's, but EOG focuses more on trying to discredit the Supreme Court and its decision in Wagner and Brown. They called it the notorious Shepard case. He's apologized for that now, but that was the strength of his argument, was that Wagner and Brown is a terrible decision. Everybody hates it, and you shouldn't extend it. We're not asking for an extension, Your Honor. Wagner and Brown is on all fours, on point on this case. And we also point out, even though they said it's a 12-year-old decision that the Supreme Court has never backed away from. They cited it with approval in the Sampson exploration case in 2017. Numerous other authorities have recognized it as established law. Laura Burney, St. Mary's law professor, said this was not an unexpected decision in light of the court's tendency to favor operators. It's a pro-operator decision. It was, and there's an irony here in that EOG contends this, tries to use this to protect itself, even though in its live pleadings in this case, it has said it's disinterested in the outcome of this case, and the Wagner and Brown case has been an issue from the beginning. They still claim they're disinterested, but they moved for summary judgment on this, and they're simply wrong. Next slide. Both DDR Gaddy and EOG rely on the Chieftain exploration case as authority for why Wagner and Brown doesn't apply here. Well, Wagner and Brown didn't apply in that case because one of the two leases within the pool unit only authorized pooling of leases, not poolings of lands. And in their response that they filed, I believe it was reply they filed last night, they suggest that we misrepresented to the court the Chieftain case. We did not. The lease did not allow pooling of lands. The unit designation, just like the lease, did not purport to pool the lands with respect to that particular lease. It only pooled the leases. And so it's readily distinguished if based on the language that we have in our pooled unit designation. We're not asking for an expansion of this at all. We are simply asking for it to be applied based on the reasoning in it and the clear holding that if you pool the lands, the unit continues. And that is precisely what has occurred here. We also have an alternative argument, and that is that they could not have that even if Wagner and Brown doesn't apply, which it clearly does, and I don't think the court needs to reach this other issue. It's just an alternative one that we put in. And actually, we didn't put it in our motion for summary judgment. It would only be a basis for denying theirs. But even if Wagner and Brown doesn't control, the 1997 release couldn't terminate our royalty interests because the lessor and the lessee didn't have the right to unilaterally terminate our participation in the snitch rental unit. And in tech, essentially, Sierra Bank has argued this, that you have to have a cross conveyancing. They say that the lease did not prohibit, that it prohibited cross conveyancing. I think that's not correct. It's not a proper reading. But if there was cross conveyancing in the unit designation, then they would have no right to terminate the term royalty owner's interest in production from this pooled unit that would include the Schnitz lands and the Rydell lands. And that's about it, unless the court has any questions. I really think this is just a clear question of law. I think the court's going to need to read both the, and I wish I would have tried to fix this on the screen, but we've had sort of a major problem at our firm. We had, my secretary's email was hacked. We've been denied access to all of our DMS system for the last 2 or 3 hours, and I have not been able to modify any of this during this time. But I think I'd like to provide the court with the Wagner and Brown decision and the Chieftain. I think those are the 2 critical cases on this.
I know I have Wagner and Brown and I have Westlaw. I will. I can get that. That's fine.
But I think that's what this turns on is the Wagner and Brown case, the unit designations, because nobody is claiming on the other side that the lease itself would not allow for pooling of lands. The lease clearly allowed for poolings of lands. If you recall, Mr. Weimeyer talked about how that lease gave the authority to pool the lands. He concedes that, and it did. And the question is, did those unit designations pool the lands? And we submit that they did. And I think it's just a clear application of Wagner and Brown. And I apologize for kind of stumbling around. I've been a little taken aback by being deprived of a lot of access to things at our computer.
No, that's fine. All right, Mr. Weimeyer, I only have about 4 minutes. I don't know if that's enough for you to get your last thoughts in. So we want to do that first thing tomorrow.
That's fine, Your Honor.
Okay. All right. Sorry, I have to rush off. This was unexpected. I will see y'all in the morning.
Thank you, Your Honor. And just carrying on to what Ms. Keeney just said, if anybody on this call gets a strange looking email from Molly Henderson, please don't open it. Please delete it. This happened about 3 hours ago, and I've gotten notices from lots of people that they got a squirrely, fishy looking email from what appears to be Molly Henderson, but there has been some kind of a spoofing or phishing attack. So please ignore and delete an email if you got one this afternoon. Thank you.
Same thing happened to Atascosa County last week. All right, I will see everyone in the morning.